Please be seated. The record will show the presence of the jury, the defendant, and all counsel. Mr. Martinez, you may continue with cross-examination.
Ma'am, your assessment in this case and your opinion in this case was based in large part on an interview that you had with the defendant, correct?
Incorrect.
So you did not base your assessment on a 44-hour interview that you had with the defendant?
I based it on the materials that I told you that I've read.
So in terms of your assessment, nothing of what the defendant told you was important to you?
I didn't say that. I said that I didn't base my opinion entirely on my 44-hour interview.
My question was, isn't it true that your opinion in this case was based in large part on an interview with the defendant?
In part.
Oh, so it's a 50-50 kind of split?
I've just never really thought about the split, Mr. Martinez. I just take everything that I get.
So you don't know?
Objection, Judge.
Sustained. Did you finish your response?
When I take a case, I explore every aspect of that case that I can.
Next question.
So in this case, though, you did talk to the defendant, correct?
Yes, I did.
And you made a determination in your mind that she was being truthful, correct?
I made an assessment that it was worth pursuing.
Ma'am, do you remember that you and I had a conversation, and during that conversation that you told me you found the defendant to be truthful?
I found the defendant to be credible, and I would move on with my investigation.
Which means you found her to be truthful, right?
All right?
No, not all right. Isn't that what you found?
I found her to be credible. Yes, I did.
And credible means the same thing as being truthful, right?
I found her to be believable, yes.
And believable means truthful, right?
You're asking me for a yes or no, Mr. Martinez, and what I would say to you is I found her to be believable enough so that I would continue with the case.
So you believed her, is what you're saying?
I believed enough to be able to continue with the case.
And when you say that you believed enough, it seems to leave open the fact that perhaps you didn't believe some of the things that she was saying.
It said that I was willing to pursue the case.
I'm not asking you about whether or not you were willing to pursue the case. Do you remember that when we started this exchange, you and I asked you about your assessment? Do you remember that and your opinion?
Yes, I do.
I'm asking you about the assessment and the opinion. Your assessment and opinion is based in part, as you said, on your conversation with the defendant, right?
Correct.
And you found her during that those conversations to be believable, right?
I found her to be believable in terms of what I talked to her about at that time.
So the answer is yes, you found her believable during those 44 hours, correct?
I found her to be believable. You're asking me about my first or my entire 44 hours?
My question indicated 44 hours, ma'am. Do you understand that?
I do understand that, Mr. Martinez.
All right, then, in those 44 hours, did you find her to be believable?
Yes, I did.
And that's part of the reason why you came in and gave us the opinion that you gave us in this case, right?
In part.
That's right. And are you familiar with the concept of secondary gain?
Yes, I am.
And the concept of secondary gain is that in situations such as this, if it's to the person's benefit, they may be deceitful, correct?
They may be deceitful.
And in this case, you found no issue with regard to the secondary gain involving this defendant, right?
I met Ms. Arias.
Judge, she's non-responsive. It's a yes or no.
Sustained. Can you answer yes or no, please?
It's not really a yes or no question.
Then we will move on.
Okay.
Ma'am, with regard to this particular case, the thought of secondary gain, did that even enter your mind?
Sure.
And did you assess it?
There's not a real way to assess secondary gain other than by looking at collateral data, which I looked at.
I'm not asking you what you looked at. I'm asking you whether or not you assessed it, yes or no.
You assess it by looking at collateral
Judge, she's just
data.
not responding to me.
Judge, it's attempting to respond. It's not a yes or no answer.
Overruled.
Ma'am, I'm asking you yes or no.
Oh, sorry. Withdraw.
Yes or no. Did you consider the issue of secondary gain in this case?
I said that I did.
And with regard to this issue of secondary gain, you, after whatever assessment that you made or whatever you considered, you decided that the issue, there was no secondary gain issue in this case, right?
I did not make an assessment of whether there was secondary gain in terms of looking, once I had looked at all the other information. There's always something that you put in the back of your head, Mr. Martinez, about what somebody's secondary gain might be. You consider that in everything. And so you take that picture and you investigate that picture and you pull in your collateral sources to do that, Mr. Martinez. And that's what I did.
So
I pulled in all the sources that I could possibly pull in to be able to assess.
So your conclusion is, based on whatever it is that you did in your mind, ma'am, your conclusion is there was
Finish your question.
that there was no secondary gain here, right?
I never said no secondary gain or secondary gain. I looked at all of the material and believed Miss Arias confessed to the crime.
Judge, she's not being responsive to the question. It's just her.
Ask another question.
With regard to this issue of secondary gain, ma'am, whether you looked at material, whether you didn't look at material, whether you did 44 hours or whether you did 38 and a half, however you looked at it, when whatever you considered, isn't it true that you really didn't reach a decision with regard to secondary gain in this case?
I considered it in my decision, Mr. Martinez.
So you did consider the issue of secondary gain and decided that there was no problem with that particular issue in this case.
I decided that there was domestic violence.
Judge, she's just not being responsive here.
Sustained. You may approach.
Yes or no? Did you rule out secondary gain with regard to the defendant?
I did not rule out secondary gain.
So that means that in your assessment, there's still an possibility then that the defendant, whatever reason she may have had, may have been less than truthful with you, correct?
It was open to my other assessments that I have a limited scope here,
Objection,
Mr.
not
Martinez.
Okay, sustained. Next question.
My question is this: since you did not rule out this issue of secondary gain, isn't it true, ma'am, that because your assessment was lacking in that aspect, that she, the defendant, could have been less than truthful with you in those 44 hours that you spoke with her?
I didn't rule out secondary gain. I looked at it in the context of all the other information. I was limited to looking at domestic violence, and I was to assess whether I believed there was domestic violence. And Mr. Martinez, I assessed that there was. That was what I was supposed to do.
Non-responsive.
Sustained. Next question.
We know what you were there to do, but in assessing domestic violence, you by necessity have to take into account what the defendant is saying, whether or not she's being truthful, correct?
Correct.
And that involves the issue of secondary gain, doesn't it?
It certainly does.
And in this case, you just told us that you did not rule it out, which means that you did not, in this case, complete an assessment that was free, if you will, of this issue of the defendant being truthful.
There's not an assessment that rules out secondary gain, Mr. Martinez.
Well, when you sit and you talk to somebody, one of the things that we talked about yesterday was whether or not you were the human lie detector. One of the things that you do have to do is make an assessment as part of your investigation as to whether or not an individual is telling you the truth or not, correct?
There is always reasonable doubt, Mr. Martinez. That's what this
Objection,
whole...
non-responsive.
No, it is
You
responsive.
may finish your question, or finish your answer, excuse me.
Reasonable doubt is part of what you go into this with, I hope. Reasonable doubt is part of what any expert witness would go into a situation with. Reasonable doubt is what the jury goes in with. It's what you go in with, and then you build your foundation, and you look to see whether or not you have the foundation for this. I believed I have the foundation for this, or I would never have proceeded.
With regard to this issue of reasonable doubt, that's the standard that you applied then. Is that what you're saying?
I always...
Yes or no?
Sure.
And in this case, when you were assessing the defendant's statement, even though you did not rule out secondary gain, you applied this other standard of reasonable doubt, right?
I apply...
Yes or no?
It's a semantics thing, and I
Judge,
don't know
she's
where you go
non-responsive.
with this.
All right. Do you have an objection?
Non-responsive.
Sustained. Next question.
So, ma'am, you did use the word beyond a reasonable doubt, didn't you?
I did. I used the word reasonable doubt.
Yes, you did with regard to this issue of what you, in your assessment of the defendant's statements to you, right?
I have skepticism when I go in and I look at that. I have doubt. Of course I have doubt.
I'm not asking you whether or not you had doubt. I'm asking you with regard to this case and the defendant's statement, why it was that you did not rule out this issue about whether or not she could have been less than truthful with you.
I didn't say I didn't look at that.
So you did rule it out then.
I didn't entirely rule out anything.
So are you saying you did believe her or not? Which of the two?
I believed her, and I continue, as I do with my other cases, to keep an open mind about what may come up. So when I do a case, I can pull out of that case at any time if I
I'm not
don't
asking you if
believe.
you can pull out of a case. I am asking you whether or not you believed her in this evaluation. That's all I'm asking you.
Yes, I believe her.
And one of the things that you did in this particular evaluation is only talked to her, correct?
In what part of the evaluation?
Any part of the evaluation. Isn't it true that you did not talk to you didn't talk to Mr. Alexander, did you?
No, I did not.
You didn't talk to any of the other witnesses, right?
No, I did not.
The only person that you talked to was the defendant, right?
Correct.
And so in basing your opinion, you based it on large part or small part on the word of one person that was involved in the relationship, right?
Objection, Ms. Faircrest, to previous testimony with what she relied on.
Well, Jimmy, answer.
I based it on all of the information that I read, not just on Miss. I read
I'm talking about
for
witnesses.
hours and hours and hours more than just looking at Miss Arias.
I understand that you want to tell us that you reviewed, you sat in your office and you read. That's not what I'm interested in. I'm interested in the mouth moving and you talking to somebody else and their mouth moving. Do we understand that that's what I'm asking?
I understand.
And with regard to that particular issue, there was only one person that you talked to, and that was the defendant, right?
Correct.
You didn't speak to Mr. Alexander, right?
Objection has been answered.
Sustained.
And in your assessment of these things, there are always two sides to every issue, aren't there?
In domestic violence.
In anything.
In domestic violence, the saying goes that as opposed to the truth being somewhere in the middle, that the truth is worse than either story because both people are minimizing and denying the story.
And you didn't speak to Mr. Alexander or anybody else about whether or not she was minimizing or changing the story or anything, right?
Or whether he was.
Exactly. Whether anybody was, correct?
I read his words, as many as I had.
Ma'am, I'm talking about talking to people.
Of course, I did not talk to other people, Mr. Martinez. I did not.
And one of the things that you told us with regard to these type of evaluations is that 90% of all communication is nonverbal, right?
Sure, you can take that any way you want.
Yes or no? That's how I want to take it.
It's not yes or no.
You didn't testify to that previously in this court?
I made a statement.
Yes or no? Did you testify to that?
In a verbal conversation, much like you and I are having, I bet people here can read in what's going on non-verbally between the two of us, and that's what I was talking about.
I'm not interested in what you may be feeling with regard to the prosecutor. I'm asking whether or not you made the statement that in a clinical interview, 90% of the communication is nonverbal. Did you make that statement?
Yes.
And with regard to this interview that you had with the defendant, one of the people that was involved in it was missing because he's been killed, right?
Yes.
And so if we apply the mathematics to it, you have a 45% chance of being wrong just right off the bat because you don't have the other person there, right?
Objection,
No.
Overruled.
Right?
No.
One of the other things that you told us yesterday was that for you, the defendant told the truth as you knew it throughout her life, but yet when this killing happened, that's when she had problems with the truth, right? That's what you told me yesterday, right?
Yes.
Which means that you, by chance or by design, investigated her truthfulness before this incident, right?
Yes.
Did you speak to her father about her truthfulness growing up?
No, I did not.
Don't you agree that, what is his name?
Bill.
Don't you agree that Bill Arias would know about whether or not the defendant had been truthful growing up?
He would have a view of her truthfulness for sure.
Right, just like anything you tell us now is a view of her truthfulness, isn't it?
Correct.
And don't you think that his view of her truthfulness has a much better basis than yours?
He has a much longer history with her, and he has a questionable history with her.
Whether or not he has a questionable history with her, she grew up in his house, didn't she?
She did.
He saw her on a day-to-day basis, right?
He did.
You didn't, did you?
No, I did not.
He dealt with her when she went to school, right?
Correct.
And he dealt with her whenever she had any issues. You did not, right?
Correct.
And he would know better than you whether or not the defendant had a reputation for honesty growing up.
Pardon?
Speculation.
Overruled. Let me answer.
Right?
Oh, yeah.
And so, did you review his conversation with the detective in which he talked about the defendant's truthfulness after the age of 14?
You may. Ladies and gentlemen, I'm going to ask you to go back to the jury room for approximately 10 minutes. Please remember the admonition. You are excused.
Please enter the jury.
The record will show the jury has left the courtroom. Please be seated. Court is still in process. Mr. Martinez, you may examine the witness.
And Judge, can I inquire though as to how much of a clip this is? Is this the entire interview or are we just going to hear part of it?
9 seconds.
I would ask for more information so that Ms. Laviolette can put it in context.
All right, Mr. Martinez.
You want more information? Do I need to address the issue of more information?
Yes, please. More updation with this witness.
With regard to this particular case, ma'am, the truthfulness of the defendant is important to you, right?
Correct.
And in fact, you spent 44 hours with her, correct?
Correct.
And in part, whether it's a small or a large part, in part, your opinion is based on what the defendant told you, correct?
Correct.
And then you went out and you corroborated what the defendant told you in an effort to see whether or not she was being truthful, correct?
Yeah, and some prior to meeting with her as well.
And in fact, yesterday when we talked about it, you told us yesterday that yes, you believe the defendant was untruthful, but her untruthfulness was after the murder. Do you remember telling me that yesterday?
Her pattern of untruthfulness.
Right,
Yes.
was after the murder, correct?
Yes.
And that I asked you specifically about before the murder, and you said you didn't see any indications that she was untruthful, correct?
With her prior boyfriends.
With anything. Remember, you told us that we talked about whether or not
I didn't have any evidence. I didn't see anything.
that she was untruthful, correct?
Correct.
But you are aware that there was an interview between her and between her father and the detective, Steve Flores, correct?
I didn't have that information.
So you didn't have that information. But if there is information out there from her father that indicated that the defendant was...
Judge, may we approach?
You may. Proceed.
Let me mark this as an exhibit, ma'am. It's exhibit 604.
She's never been honest with us since then. And she was probably 14 then.
Did you hear that?
No, I didn't.
All right, let's play it again.
She's never been honest with us since then. And she was probably 14 then.
Did you hear him say, she hasn't been honest with us since then, and she was 14? Did you hear that?
Yes, I did.
With regard to this particular case, this is not something that you knew when you testified yesterday, correct?
No, it is not something I know.
Pardon?
No, it is not something I knew.
Isn't this something that you would have wanted to consider in deciding whether or not the defendant was being, whether or not you were going to believe the defendant in this particular case?
Objection, Judge, it would be inappropriate to ask the witness this without context to the entire interview.
This is outside the presence of the jury. You may answer the question.
Well, I would not take a sound bite of anything and make a decision on it. So I'd want to hear the whole tape. And I'd also want to put in perspective the things I'd heard about Mr. Arias. And I'd want to put into perspective what I know about teenagers.
But my question to you is, the fact that this person, her father, is saying that she hasn't been honest since the age of 14.
Objection is characterized what he said.
Sustained.
Well, let's hear it again, okay? Then I'll ask you a question.
She's never been honest with us since then. And she was probably 14 then.
Did you hear what he said?
Yes, I did.
He said she's never been honest with us since then, right?
Right.
And he also said she was 14, correct?
Correct.
Isn't that go contrary? Doesn't that fly in the face of what you just testified to yesterday, that she was always honest before the killing?
Asked and answered.
It doesn't fly in the face until I've assessed it. I need to find out. The information I had, I didn't have information that she had lied. When you get information from a parent that a child lies to them during teenage years, that does not necessarily characterize someone as a liar or not. And so I would want to take that into account with the information I had that was regarding Mr. Arias as well, and his rationale for perhaps for the reason that she did lie to him.
What you're saying is that you would consider it and then you would explain this statement.
I would consider it, and then I would decide what I was going to do with it once it was considered.
Right. And it would be part of the file then, right? That's something you would consider then, right?
Yes, it would.
I don't have anything else.
So, did you have any questions on this issue?
Not until she is able to have a better context of what this is actually about. I'd like to be able to either see the entire interview.
All right, Counsel Park.
before the
Yes.
jury comes in.
Mr. Martinez, are you ready?
Oh, yes, I am. Thank
All
you.
right, we'll bring in the jury.
Please stand for the jury.
Please be seated. The record will show the presence of the defendant, the jury, and all counsel. Mr. Martinez, you may continue.
With regard to this issue of the defendant's truthfulness, one of the things that you learned as part of your investigation was that the defendant said that after the murder, she had cuts on her hands because she had cut them on apples, right?
Yes,
And did you also hear, for example, other stories other than that she had cut them on her hands on apples while she was cutting apples? Did you hear anything else about that?
about the cuts?
About the cuts on her hand, how they came about?
I don't recall hearing any other story other than the cuts on the hands for the apple.
And so that's one of the things that you believed when you were talking to the defendant, that the cuts that she suffered during this killing were as a result of her cutting apples, right?
I didn't believe that.
So as you're going along, you're making assessments as to what you believe and what you don't believe, right?
Oh, wait a minute, I'm sorry, I was unclear. You're saying that I believe that she got the cuts from the apple?
No, I'm saying that isn't it true that your notes reflect the fact that your information is that the cuts the defendant had after this killing resulted when she was slicing apples, right?
Right.
And you believe that, right?
I don't recall that I focused on that as much as what I was routine to do, which was look at whether or not there was domestic violence in the context of the relationship, which was really what I was what I came on to do.
I'm not asking you whether or not you focused on that. You understand that?
I
You understand that?
I understand what you're saying.
I'm asking you whether or not you believe the defendant when she told you, or the information that you received during this investigation, whether or not you believe that the cuts to her hands were caused while she was cutting apples, green apples.
Objection, Judge Foundation, as to when, where this happens.
Sustained.
Well, ma'am, let me show you your notes about this particular incident, okay?
I may need my glasses.
Did she get her glasses?
Yes, you can put it in your glasses.
Ma'am, take a look at Exhibit 605, and take a look at the highlighted portion. And once you've read the highlighted portion, let me know.
Your Honor, the witness read the entire page so she has context of it.
Yes.
Did you read the entire page?
Yes,
May I have it back, please?
sure.
This is your handwriting, right?
Yes, it is.
And this deals with this issue about the cuts on the hands that the defendant received at the time of Travis's death, right?
Correct.
And in it, your notes reflect that Jodi said cuts on her hands were from cutting apples, right?
Correct.
So with regard to that issue about cutting apples, did you verify whether or not that may or may not have been true?
No, I did not.
You could have gone to collateral sources like you said, right?
I could have.
You could have gone, for example, to the police report, right?
I could have.
You didn't do that, right?
I did read the police report.
And do you know whether or not there were any statements in that police report of what the defendant said caused the cuts on her hands?
No, I don't.
But you did read the police report, right?
I read the police report very long ago and didn't reread it.
So the answer is you did read the police report, right?
I did read the police report.
And do you know whether or not, from your memory, whether or not there was any indication what she said caused the cuts on her hands?
No, I don't.
One of the things that you told us was that you reviewed, well, let's do it this way. Did you review her statements to the police?
I did. I reviewed them a long time ago. And
I'm not asking you, am I asking you when you reviewed them, ma'am?
You're
I am not.
asking me if I reviewed them, and I'm putting that in the context that I reviewed them a very long time ago.
I'm not asking you for a context. Do we understand each other?
I understand you don't want context.
Ma'am, Judge, I would ask that she be admonished for the last comment as to what the prosecutor wants.
Your Honor, she answered the question.
All right, move on. Next question.
Ma'am, with regard to this particular case, you did review her statements to the police, right?
I did.
You reviewed the videotapes, right?
To the police?
Yes.
No, I did not.
So you just reviewed a transcript of it, right?
Correct.
And in that transcript, isn't it true that there's a different version of how she cut that finger?
I guess there is, because you're telling me and I don't remember.
No, I
can
don't
tell-
want you to, so.
I don't remember. I don't recall, Mr. Martinez, honestly.
All
I
right,
don't recall.
let's assume that there were 4 different versions of how that finger was cut.
Objection, mischaracterizes testimony.
Assume that there are 4 different versions of how she cut her fingers. Wouldn't that cause any problems for you in evaluating this case, because there clearly is an inconsistency there?
Mr. Martinez, people lie.
Yes or no?
No, that would not be a complete answer.
All right. No, it would not cause a problem for you, or yes, it would cause a problem for you.
I cannot answer that yes or no and be honest about how I answer it.
With regard to this case also, you were aware of this issue involving gas cans that the defendant supposedly asked her boyfriend about before she took this trip. You're familiar with that, right?
Daryl Brewer.
Right. Yes.
Yes.
You're familiar with that. And you're familiar with that, the fact that before she went on this trip, she asked Mr. Brewer for the use of 2 gas cans to take on the trip, right?
I am.
And in fact, that caused you problems, didn't it?
I'm not sure what you mean.
Well, that caused you problems in terms of the defendant's truthfulness, didn't it?
I don't,
You look over there. No, I'm asking the question.
No,
That caused you
I'm-
problems, didn't it?
I don't believe it did. I think.
Well, let's take a look at your notes.
All right.
Let me show you an exhibit first.
Okay.
To give you a little context, take a look at exhibit 607. Read the whole thing and then let me know when you're done.
All right.
Have
All
you
right.
read it?
Yes.
That's your handwriting on this particular page, right?
Right.
And it does reference this issue involving the borrowing of 2 gas cans from Daryl Brewer, right?
Right. But
Yes or no, does it?
yes, it does.
And doesn't it indicate that on the last week of May of 2008, Jodi told Daryl she needed to borrow 2 gas cans because she was taking a long trip to Mesa? Doesn't it say that?
In part, it says that.
It does say that, though, doesn't it?
In part, it says that.
Well, let's read the whole part. Last week of May of 2008, Jodi told Daryl she needed to borrow 2 gas cans because she was taking a long trip to Mesa and didn't want to run out of gas, right? That's what it says.
That's in part what it says. That's not what the rest of it
I'm
says.
talking about the issue involving the gas cans. That's all it says about the gas cans, doesn't it?
Well, it talks about the
gas
trip.
cans. Take a look at it.
I looked at it. I took notes on what people said. I took the notes right off what people said. I don't necessarily have a problem with what I said. I took notes to ask questions.
And isn't that how you do did the evaluation in this case? You take what somebody said, and then you look at everything else, and then you come in and tell us that this is domestic violence, right?
This doesn't have anything to do in particular with the domestic violence I was assessing, Mr. Martinez.
You used the same procedure with regard to this particular issue that you used with regard to any other issue in this case, right?
I'm not certain that that would be true, but I'm not certain what you're referring to. What I did with this case, if you want to know what I did with this
No,
case.
I don't want to know what you did with this
Okay.
case. I want you to answer my question. And my question to you is, isn't it true that you've been telling us that in this case, You've looked at writings and you reviewed those and took those into account, right?
Correct.
Isn't that same thing that you did with regard to the gas cans? You read it, you took it into account, and you made notes on it, right?
I did.
And with regard to that particular issue, that caused you some problems, didn't it?
No, the gas cans didn't cause me problems.
Isn't it true that you had an issue with that because you believe that perhaps the defendant may not be truthful? Isn't that a problem for you?
I think my question was, what does this mean on the side of the page? And I was asking about what that meant. I wanted to get a description of what erratic behavior meant.
Actually, isn't it true, ma'am, that what you thought back then is why did the defendant want to borrow 2 gas cans from Daryl? Did she know she was going to...
Your Honor, he's reading from something that's not been marked or in evidence.
Sustained.
Isn't it true that you were concerned that she had told you about the trip, and now you have this issue about her going to Mesa, and then you said, I thought this was a last-minute decision. Didn't that create a problem for you?
I didn't hear the question.
Isn't it true that you had questions about it because you thought it was a last-minute decision to go to Mesa?
I still think it was a last-minute decision.
And that caused you problems in the context of exhibit number 607, which is what she told you about Daryl and the gas cans, right?
I had a problem.
Take a look at...
I had a question. You're saying a problem, I had a question.
Take a look at 608. See if you recognize the highlight, the whole page.
I did ask her that.
Hold on. You may-
Ma'am, did you read exhibit 608?
Yes, I did.
That's in your handwriting, right?
Correct.
And in fact, the approach that you took here were some looking at things that you had problems with in this case,
I
right?
had questions about it.
Questions that you had in this case, right?
Yes.
And one of the questions that you had in this case involved the gas cans, didn't it?
Yes, it did.
And in fact, you indicated that your words were something to the effect of you thought it was a last-minute decision and it was creating a conflict for you, right?
I wanted to make sure that it was a last-minute decision. I had questions that I wrote throughout, and I asked those questions.
And that was one of the questions that you had, was that
Yes.
you thought this was the last-minute decision, right?
Yes.
And thinking that it was a last-minute decision, in your mind, it did not make any sense that she would go to Daryl Brewer and ask for 2 gas cans to go to Mesa, because that happened many days before the trip started, right?
Objection is mischaracterizing what Ms. Arias actually said. She never said that. The summary of the notes are not what Ms. Arias said.
Overruled. You may continue.
Okay?
Okay.
You may answer.
Oh, I had a question about the gas cans, and one of the questions I had was because I don't know how far Utah is from Wairika. I wanted to know why she needed gas cans. That's all.
But your notes,
And I wanted to know if there was a decision to go to Mesa, which I had written, and later in that same page, it talks about the trip to Southern California and Utah. So I wasn't clear about whether Mesa was an intended trip or not, and I
Well-
wanted to find out whether it was.
are you saying, ma'am, that you did not write in your notes last week of May 8, Jodi told...
Objection, Your Honor, to even
An exhibit, it's not in evidence.
Absolutely am. I'm impeaching her now with the statement because if you want, I'll address it.
Judge, it's not,
Approach, counsel.
in your assessment in this case, what you've been telling us is that you took statements from a number of people, and we call them collateral sources, right?
Correct.
And you looked at those statements from other people, these collateral sources, and then you compared them to other collateral sources and any statements by the defendant, right?
Correct.
In this particular case, you viewed the statement of a collateral source, right?
I did.
Daryl Brewer, right?
Correct.
And in viewing the statement of Daryl Brewer, there was this statement about the defendant requesting or asking to borrow some gas cans in late May of 2008, right?
Correct.
And with regard to this statement from Mr. Brewer involving the gas cans being borrowed in 2008, the indication was that the defendant told him she needed to borrow 2 gas cans because she was taking a long trip to Mesa and didn't want to run out of gas, right?
Correct.
In terms of you saying Utah and talking about Utah and how far Utah is, this page, ma'am, take a look at it again. It has no mention of Utah whatsoever, does it? Read it.
Jodi said she was going to visit.
No, read it to yourself.
It does mention Utah.
And it mentions it at the very bottom, doesn't it?
No, it mentions it about in the same paragraph as the question about Mesa, and it mentions the Grand Canyon.
All right, go ahead. Let me have it back.
Okay.
But it mentions Utah, ma'am, after she goes to Mesa, right?
It says Mesa, and then it says the other things.
Right. It talks about what she's going to do. But it doesn't talk about Utah first, does it?
No.
And that created a problem for you, didn't it?
I had to ask a question.
Ask the answer.
Didn't it?
It created a question for me.
Okay, it created a question for you because you thought this decision to go to Mesa was a last-minute decision, right?
Correct.
And what you did is, with regard to this issue, even though you reviewed a statement to the police and all the other items in this case, you decided to resolve this conflict or this question in favor of the defendant, right?
I asked the defendant about it. She told me that she had not said she was going to Mesa, she was going to Utah. And also the journals indicated, and the IMs when they were talking about planning trips. So I used other things to look at that. But yes, I had a question about it for sure.
And you decided to resolve it in favor of the defendant, irrespective of what you used, right? Irrespective of what sources you used, right?
No, in respect to other sources I used. And I don't remember the police report. I'm very sorry. I don't remember that.
With regard to this issue as to whether or not she was going to Mesa first, ma'am, isn't it a fact that you could have just called or had an interview with Mr. Brewer to try to determine what it was that he said? You could have done that, right? You do that as part of your investigations, don't you?
I could have, but I was basically told to rely on the information that I had.
Well, now you're indicating that you were restricted somehow by somebody. I don't want to know who you were restricted by. Have you ever voiced an objection here during testimony that you were ever restricted in your approach in this case?
No.
And in this case, no one was directing your investigation, was it? Were they?
No.
You're independent. In other words, you have an independent assessment here to make an independent assessment, right?
Yes.
And as part of that investigation, you could have spoken to Daryl Brewer to see whether or not what his recollection was, right?
I asked about interviewing other people, and I was given the information, the collateral sources.
Yes.
Isn't it true then that with regard to your finding that there was domestic violence in this case, because you didn't do this interview, and it talks about different stories, isn't it true that your assessment of domestic violence is deficient?
No, I don't believe it is.
Even though you didn't interview Mr. Brewer, correct? Yes or no? I don't want to get any further than yes or no on this one.
Okay. I didn't interview Mr. Brewer.
And even though you didn't interview, because you didn't interview Mr. Brewer, your assessment in this case, at least to a certain extent, is lacking.
I don't think so.
And you didn't interview, well, you're the one that told us that with regard to these kinds of things, conversations are only part of, conversations can form a part of your investigation, right? You did say that though, right? Yes or no?
The conversations are part of my, right.
And in fact, in other cases, you have conducted interviews with other people, correct?
In most murder cases, I have not.
So
I've used collateral sources.
So you're saying that with regard to your assessments in criminal cases, don't restrict it to murder cases. With regard to the criminal cases, what you're saying is you don't interview other people, you just interview the defendant and look at collateral sources. Is that right? Is that what you're saying?
It depends on the case, and it depends on what is available for me to review. In some cases, there are financial restrictions. They say these interviews have been done. I'm given those interviews. So it depends on the attorney, and it depends, and it doesn't matter whether it's the prosecution or the defense, Mr. Martinez. There's a limit to what they give me. And
I'm really not asking you to go into that, and if you don't mind not going into that area that you just went into, okay?
Right.
I'm just asking you whether or not, it's a yes or no, and if you can't answer yes or no, tell me and we'll move on, all right?
Okay.
With regard to your other criminal cases, isn't it true that in those other criminal cases, on occasion, you have conducted interviews? Yes or no?
I really am reflecting on the criminal cases, trying to reflect on the criminal cases that I have done. Generally, it's been paperwork.
Generally means that you have, at least on a couple of occasions.
I'm leaving it open because I know that you are, it's like very precise, and I am not certain.
So you don't know is what you're saying?
Yes, I'm not certain.
Ma'am, one of the things that your investigation revealed in this case, and we've talked about this issue of secondary gain, and we talked about some inconsistencies here. One of the things that your investigation revealed was that the defendant is very manipulative, isn't she?
I don't think that I don't believe I said she was very manipulative.
Isn't it true that you reviewed collateral sources that indicated the defendant was very manipulative?
There were collateral sources that said she was manipulative.
Right. Isn't it true that, in fact, it was people that were close to her who indicated, for example, that...
Objection, Judge.
May we approach?
You may approach. You may continue.
You received information that the defendant was manipulative, correct?
Yes.
In fact, you received information that the defendant was not abused. She just,
Objection, Judge. This is what we just discussed.
Overruled to that question.
isn't it true that your investigation revealed that she was not abused, but liked to play the victim? And that's part of the manipulation.
I don't recall that.
Let's take a look at your notes.
Okay.
Take a look at Exhibit 609, read the whole thing, and if you don't mind concentrating on the highlighted portion. Have you read the whole page?
Well, I scanned it.
Go ahead and read the whole page, please. You reviewed it, correct?
Yes, I did.
Isn't it true that your investigation revealed that the defendant liked to play the victim?
This was about high school, Mr. Martinez.
Whether or not it's from high school, ma'am, isn't it true that that's part of something that you thought it was important enough to write down?
Let me answer that correctly. Let me answer that fully. I took notes on every interview and I wrote down the essence of the notes. In that particular interview with Zaina, her high school friend or junior high friend, her friend was talking about Jodi liking to play the victim. And that was in junior high or high school. So that was a piece of what I took into consideration, sure.
And playing the victim and being manipulative, that's a character trait, isn't it?
It doesn't have to be a character trait. It can
Well,
be a transient situation. It can be situational, Mr. Martinez.
It can be situational, but there's no indication anywhere that this was a situational thing, was there?
It's the observation of one other young girl.
Who knew her well at the time that she was growing up, right?
A young girl.
Right. So you're saying that when an individual is of a certain age, you can't pay attention to what they say, right?
No, I paid attention to what she said and weighed it with the other things that I read.
So you did consider this information, is what you're telling us,
Sure.
in making this assessment. And the information that you considered was that growing up, the defendant liked to play the victim, right?
From one source. That was one source. That
Did
was
did I ask you what source? I did not, did I?
I guess I'm trying to figure out if you want a complete answer or not.
I want you to answer my questions. Isn't it true that you just told me that you considered this information? Yes or no?
Yes, I considered it.
Isn't it true that the information that you considered was that the defendant was not abused, but she liked to play the victim? Yes or no?
Contrary to other sources, yes.
Am I asking you about contrary sources, ma'am?
Contrary
Yes or
to
no?
other sources, yes, that would be true.
And I'm not asking you about contrary sources. I'm asking you whether or not that's something that you consider. Yes or no?
Objection, asked and answered several times.
Yes.
And this information that she, whatever it was, the term is manipulative, this is something that you had when you were considering this whole issue of abuse, right?
Correct.
And again, you gave the benefit of the doubt to the defendant because you never even asked her about it, right? Did you even ask the defendant about her playing the victim?
I asked her about that report, but I also looked at
So you
statements from Jodi's mother, Jodi's sisters, Jodi's grandparents, and Jodi's siblings in looking at the issue of Jodi playing the victim.
But you didn't speak to the defendant herself directly about it, did you?
I don't recall if I did or not.
Do your notes reflect that you ever talked to the defendant about that?
My notes don't reflect everything I talked to the victim. Or
Would it have been
the defendant
important
about.
in this case, since we're talking about abuse, to ask the defendant whether or not she had manipulated people into thinking she'd been abused before?
I had talked to her about being abused before, and I never got an impression from her or from other collaterals that she was in the habit of playing the victim. And what I'm looking for are patterns of behavior here, Mr. Martinez, not isolated instances.
I'm not asking about patterns. I'm asking about whether or not you asked her specifically about this issue, about her being accused of playing the victim when she was not abused.
Objection, ask again.
I do not recall, if I ask her specifically.
But isn't that what we're here to discuss? Whether or not the defendant was abused in a domestic violence situation? Isn't that what we're here to discuss?
Yes,
And so...
in the relationship with Mr. Alexander.
I understand that, but we're talking about abuse though, right?
We're talking about the relationship specifically with Mr. Alexander.
And if in another circumstance, the individual had pretended to be a victim of abuse, you don't consider that to be important in your assessment.
This characterizes the notes that were on there and her testimony.
Overruled, you may answer the question.
No other collaterals suggest that Miss Arias is playing the victim or that she did. In fact, they talk about her being a victim of her father and her mother at times.
Do you consider this information to be so unimportant that you didn't consider it? This information, was it so unimportant to you that you didn't even address it with the defendant?
I am sure I addressed it to some degree.
Then tell me what she said with regard to this issue about playing the victim. Tell me.
Nothing that stands out in my mind.
So you can't tell me anything, correct, about what she
I
said?
can tell you that she had...
Yes or no? Can you tell me anything that she said with regard to this issue?
I cannot tell you specifics, no.
Ma'am, the other thing that we know is that not only is there this indication that she was manipulated at that age, isn't it true that after she...
Objection, mischaracterizing the testimony. Manipulative at that age. That's not what it was.
Sustained rephrase.
With regard, isn't it true that we know that at that age, whatever the age that was, that she was perceived to be somebody who played the victim even though she was not abused? In addition to that, isn't it true that your investigation revealed...
Objection, not no question.
Overruled, overruled.
Isn't it true that your investigation revealed that after she killed Mr. Alexander, she was very manipulative?
After she killed...
Yes.
Part one, I have one collateral source that says she was manipulative. So when you characterize me saying that she was manipulative, that is incorrect. Part two is, yes, I'm not sure what you're talking about in terms, if you could describe what you mean by manipulative.
No.
Afterwards, I would
I'm asking
answer.
you whether or not you remember, as you're sitting there, any information from any source indicating that the defendant was manipulative shortly after she killed Mr. Alexander.
Manipulative regarding what or to whom?
Manipulative is do you understand what the word manipulative means, right?
Well, I'm not sure how you mean it,
No.
Mr. Martinez.
Use the Webster Dictionary definition of it. What does manipulative mean to you?
Manipulative can mean manipulating facts. It can be deceiving people. Is that what you're asking me?
I'm asking you for your definition of manipulative. That's what I'm asking.
If you're asking me if she,
No, I'm not. I'm asking for a definition of Webster's.
He's not allowing her to finish her answer.
Overruled. Ask your next question.
Give me your definition of manipulative, whatever it may be.
my definition?
Yes, as you applied it in this case.
Asked and answered. She already answered this question.
Overruled. You may answer the question.
That someone can manipulate or deceive or I haven't been asked for a Webster's dictionary definition, but basically that you can manipulate data means you can change them, that you can deceive or tell half-truths, that, you know.
And with regard to the defendant, isn't it true that you received information that she was manipulative shortly after, in her relationship with men, shortly after the killing?
With men?
Yes.
With what men?
Well, do you remember, do you even have any memory of your notes involving what the defendant did after she returned to Wairika?
Objection argumentative.
Overruled. Are you talking about her trip to see Ryan in Utah?
No, ma'am.
Are you talking about her experience in the restaurant? I have no idea what specifically, Mr. Martinez, you're talking about.
Do you remember her experiences at the Purple Plum? Do you remember
Yes.
about that?
Yes.
And do you remember that you have information involving the Purple Plum with regard to her interaction with men?
Yes.
And that interaction with men indicated that she was...
Objection, Judge.
May continue.
Ma'am, do you need your notes to refresh your recollection as to the incident at the Purple Plum?
Is this regarding, there were several interviews about the Purple Plum, so I'm not sure which interview you're referring to, Mr. Martinez.
I'm referring to the one involving whether or not the defendant was manipulative with men.
there was an interview with a waitress who said she was manipulative or only was only nice to good-looking men.
How about the interview with the manager, Gary Franco? Are you familiar with that?
I am familiar with it. I don't remember every detail of it. If you
All
like
right,
me
let
to
me go
look
ahead
at
and
that.
provide that to you then.
Sure.
Take a look at Exhibit 610. Please read it all, including the margins.
Sure.
I may have it back. You're done reviewing that, correct?
Yes, I am.
These notes are in your handwriting, correct?
Yes, they are.
And you completed them as part of your investigation in this case, correct?
I was taking notes on the interview. Yes.
And this is what you did with regard to this investigation. You would look at collateral sources and you would take notes, correct?
Correct.
And you would use them either then or later as part of the evaluation. It's something you considered, right?
Yes.
And in this particular case, there was an individual that was the manager of the Purple Plum, right?
Correct.
And you talked to the defendant. She worked at the Purple Plum at some point, right?
Yes, she did.
And when she worked at the Purple Plum, there was this indication, or your investigation revealed, was that the defendant was manipulative towards men, right?
Objection foundation. I mean,
Sustained.
Well, ma'am, what do your notes indicate that, well, do you want the date, ma'am? Take a look at the date on Exhibit 610, if that refreshes your recollection as to when this happened. I'll point it out to you.
Okay.
What date are we talking about where this manipulation occurred?
June 13th, 08.
And during this manipulation, it involved men, the defendant and men, correct?
Correct.
And specifically, it involved the defendant, her interaction with men, correct?
Correct.
And your investigation revealed that she would feign.
objection, hearsay.
Approach, please.
And the part of the investigation that you found out was that the defendant was manipulative in her interaction with men, correct?
Objection.
Overruled. You may answer yes or
Correct.
no.
She was flirtatious with them. I don't know if she was manipulative with them. He says she used them.
All right. Using men, given your previous definition, that's someone who's manipulative, correct?
That would be correct.
And so, given that, isn't that something that it's something that you considered and ultimately rejected in favor of the defendant, right?
Actually, I looked at behavior after the homicide, and that was after the homicide,
Right.
that I would consider would be aberrant behavior, and according to her other history in working in restaurants, that was never part of it. And at working at Casa Ramos, that was not part of it, according to the owner. So I looked at behavior after the murder or after the killing, and I would say that unusual aberrant behavior would be part of that.
And that's your assessment, if you will, of her behavior, correct?
Yes,
And that's your assessment of her behavior, even though the indications are what they are as part of the investigation, correct?
the indications,
They,
the indications, there are contrary indications with Casa Ramos differently than Purple Plum.
But my point is that you decided to disregard these indications that she was manipulative as part of your assessment in this, as part of your opinion in this case, right?
I didn't disregard them, I considered them.
You considered them, but chose to find them to not be of enough value to factor into your assessment, right?
I factored in behavior her behavior toward men prior to the killing. I factored in her behavior with both restaurants. I factored them all in.
You've already told us that, but my question to you is more pointed. You came in here and you indicated that the defendant was manipulated by Mr. Alexander, correct?
Abused by Mr. Alexander.
All right, and that has a component of manipulation, correct?
Yes, it would.
And in fact, in this particular case, what we have is the defendant exhibiting manipulative behavior after she killed him, right?
Correct.
And what you're saying is, even though she's exhibiting manipulative behavior, I'm not going to believe that manipulative behavior. That's what you're saying, right?
No, I'm not saying that.
So you
I'm
do
saying
believe-
I believe that she could have been manipulative with men at that time. I'm not disregarding that.
If she is manipulative with men, you would agree that Travis Alexander was a man, right?
I said she was.
Yes or no?
Her testimony as to when the supposed manipulation took place.
Overruled.
Yes or no? Was Mr. Alexander a man?
Yes, he was.
And you just told us that she could be manipulative with men. You just told us that,
I
right?
said at this period of time, she was manipulative. And in Casa Ramos, which was during that period of time, the statements were that she wasn't. So I have no evidence prior to Mr. Alexander that she was manipulative with men. I just don't have that evidence.
What you're telling me is that somebody is telling you, according to you here, that there's no information on the left side, but on the right side, somebody's being very specific that she's manipulative, right? That's what you're telling us, right?
objection is characterized as the testimony.
Specific as to manipulation. There's no specificity.
Overall.
Right? That's what you're telling us. You have two competing views, according to you, right?
I have competing views.
Yes or no?
After the killing.
Yes or no? You have two competing views. Casa Ramos on the left side, Purple Plum on the right side. You have two competing views, right?
Those two competing
Right.
views.
And what you decided to do as part of this evaluation is tell me, well, I believed what people were saying at Casa Ramos, right?
No, I did not say that.
Well, you are disbelieving what people are saying at the Purple Plum, right?
I am also looking at,
Yes or no? Are you disbelieving what people are saying?
I have other information about what people said at the Purple Plum that I also took into account, Mr. Martinez.
And so what you're saying is that you're disbelieving what was said at the Purple Plum about her being manipulative. That's what you're telling me, right?
Even if I say I believe that she was manipulative at that time, it doesn't mean I believe as a characteristic that she is. I could believe that she was manipulative at that time. It does not, it's situational. It doesn't mean that I believe as a characteristic of Miss Arias that she's a manipulative person.
And what we know with regard to this assessment is that when she was younger, we have information from you that she was not abused and she liked to play the victim, right? You have that information, right?
You're
Don't answer the question.
mischaracterizing.
Don't answer the question. I'm sorry, repeat objection.
The question is mischaracterizing the testimony.
Overruled. You may answer.
Right? You told us about that when she was younger, right? That you have that information, right?
I have one friend
Yes
saying
or
that.
no?
I have one friend,
Yes or no?
yes, one friend.
And then you're now telling her, and this is when she was younger, right? And now you have her immediately after the murder, 5 days after the murder, exhibiting manipulative behavior. Yes or no?
Yes,
So what you're saying, though, is at one, you have an expanse of years in between, right?
yes,
And what you're choosing to say is, well, even though there was this behavior here when she was younger, and there's the same behavior when she was older, you're choosing to say that was aberrant. That is not something that was a characteristic of hers. That's what you're saying, right?
I'm saying that what I hear from one teenage friend of hers is limited compared to what I heard from other sources in regard to Miss Arias. And so there is a preponderance of evidence on the one side and not on the other. That's what I'm saying.
Is that your standard that you use when evaluating this evidence, the preponderance of the evidence? Is that what you're using? One is more likely true than not? Is that what you're saying?
I'm saying that when I have numerous collateral sources.
I'm asking for your definition of preponderance of evidence.
And I'm going to tell you what it is.
My question is more pointed than that. Does it mean more likely than not?
No,
You're using it differently.
I am.
What's the standard in one sentence that preponderance of the evidence means to you?
For me, preponderance of evidence means that I have looked at all of the evidence that I have available to me, and I have gone through it and looked at what appears to be the truth. What for me makes sense, what for me, after I weigh all of the evidence, makes the most sense to me. And that's what I have to go on. What I have been presented with is what I have to go on.
And your definition of preponderance then is what appears to be the truth. That's what you just said in part, right?
In weighing the evidence.
Right. And so in a sense, what you're saying is you're a human lie detector, right? Because whatever may appear to be the truth to you may not appear to be the truth to somebody else, right?
I would not call myself a human lie detector. I think
Well,
that
you
mischaracterizes me.
You evaluate this in terms of what appears to be the truth to you then, right? Right?
And that's the context of what I'm saying today.
And what appears to be the truth to you in this case, in terms of the Purple Plum and the Casa Ramos example, to you, the Casa Ramos example appears to be the truth. Yes or no?
I didn't say that.
Well, we were talking about it in the context of the Purple Plum. Didn't you tell us that that's what appeared to be the truth to you?
Mischaracterizes her testimony.
No.
You may answer.
I said that what they said at the Purple Plum could be true.
So she could be manipulative towards men at that point, right?
I said that
Yes or no?
situationally, it
Yeah.
appeared that could be true.
So
That
if
was
it's-
their perception.
So if it's true that she could be manipulative towards men on June 13th of 2008, it could also stand to reason that a week or 2 weeks before, let's just go with 2 weeks, 2 weeks before that, she could also be manipulative towards men, correct?
It doesn't stand to reason.
I'm sorry, the objection
Speculation.
overruled.
It
Correct.
doesn't stand to reason.
I know you're saying that this is your view of what you believe is the truth, but isn't it based on the continuum that we've established here, young, right after the murder, isn't it also true that it could be true that she was manipulative before the murder?
Objection.
Because
Approach. You may continue.
with regard to this issue of manipulation, it could be that we've seen two instances of manipulation here, correct?
Objection made. Foundation.
Sustained, rephrase.
You told us about an incident that you investigated when she was a teenager, and you told us about an incident that you investigated on June 13th of 2008, correct?
Correct.
Prior to, those are incidents that can be characterized as manipulative, is what you told me, right?
Objection is characterized as an incident. When she was a teenager, there's no incident.
Overall,
Correct?
that wasn't an incident.
These statements that were made when she was a teenager, and somebody saying that she played the victim when she wasn't abused, could be characterized as manipulative, yes or no?
Objection is characterized as the evidence.
Overruled. You may answer.
Correct?
They could.
And you've already talked about the case involving the purple plum, and that could also be characterized as manipulative, correct?
Yes, it could.
Do you remember that we talked yesterday about a text message that was sent by the defendant to Mr. Alexander, and this text message was sent mistakenly? Do you remember that we talked about yesterday?
Yes,
It was to an individual named Stephen. Do you remember that?
yes,
And that as part of that text message being sent out, Mr. Alexander became upset, right? You
became
saw that
very
text.
upset.
Right. And then the defendant created another text message and sent it. And it was almost the same as the first one. Do you remember we discussed that?
Yes,
Could it be that this individual that is manipulative, given those two incidents, could have sent that text message just to get a rise out of Mr. Alexander and manipulate him into paying attention to her?
are you asking me hypothetically if someone who is not known to be manipulative with other men that she's with and spent incredible amounts of time with, if she could do a manipulative behavior? Are you asking me if it's possible for her to do something?
Isn't it possible that that was manipulative also?
It's possible that most of us have done something
I'm not asking
manipulative.
about you. I'm not asking about me. I'm asking about her.
It's certainly possible.
And with regard to her going to visit Ryan Burns, you talked to her about that, right?
Yes,
And when she went to visit Mr. Burns, one of the things that happened was that they were involved in some sort of sexual contact. Do you know about that?
they were making out.
And during the time that they were making out, one of the things that the defendant, do you know why the defendant was making out so shortly after the killing? Do you remember what she told you about that?
I remember that she was trying to act normal.
She was trying, which is another form of manipulation, isn't it?
I think that's manipulating yourself. I think it's trying to make yourself feel normal in a situation that isn't.
Well, ma'am, if she has Mr. Burns laying down and she gets on top of him and straddles him, do you really think that she's trying to make herself feel normal, or do you think she's trying to make him feel normal?
Do I think?
Ma'am, we have evidence.
I don't know who I think she's trying to feel normal. I think I would want to feel normal, or anybody would want to feel normal after what happened.
So you're now injecting yourself into this. You're saying that your standards are that if you killed somebody, you would that same day go and have some sort of sexual relations with somebody else. That's the standard that you want to apply?
You know, I'm not saying that, Mr.
Well,
Martinez.
ma'am, isn't that what you said? If I were, didn't you just tell me that?
Let me rephrase that.
I'm not asking you to rephrase it. I'm asking you a question. Didn't you just say, if it were, or if it were me, something to that effect?
I think you probably know that the answer to that is that is not my standard. No.
You don't, ma'am.
I don't go and
Ma'am,
behave.
we don't, you understand that your standards, personal standards, are unimportant here, correct?
Okay.
But you keep interjecting it by saying, if it were me. Do you agree then that by you saying, if it were me, you are attempting to interject your standards here, right?
I misspoke.
When with regard to your standards, in fact, there was an issue that was created in this case because of your standards, wasn't there?
I don't know what you're referring to.
Do you remember that you told me in our interview that you didn't ask certain questions of the defendant because you were old-fashioned and you were embarrassed?
Oh, it's sexual questions?
Ma'am, isn't it true that you told me that you were old-fashioned, yes or no?
There were sexual questions I did not ask because they do not come easy to me to ask. Yes, that's true.
It was much more strong than that. You indicated that you were old-fashioned, yes or no?
Yeah, I'm old-fashioned.
And because you were old-fashioned, that restricted you in asking the defendant certain questions involving the sexual aspect of hers and Mr. Alexander's relationship, right?
I read about them.
Ma'am, I know you want to tell me that you read about them, but isn't it true that you did not ask her about them, right?
I asked about them later, after I had spoken with you, after our interview in November. There was a sex tape. I did ask her questions.
I'm not asking about the sex tape, ma'am. I'm asking...
There were questions I did not ask that I had not asked when you and I had our interview, and there were questions I asked after that.
Isn't it true that, first of all, you told me that you were old-fashioned, right?
Well,
Abstain.
After that, isn't it true that you are now telling us that you then went to talk to the defendant, right?
I asked her some questions.
You did go to talk to the defendant after our interview, right?
Correct.
You were still old-fashioned. You were even older when you went to talk to her, right?
Objection.
Afterwards.
I was.
Well, your standard of being old-fashioned hadn't changed from the first time to the second time when you went to visit her, had it? Yes or no?
My standard changed because I was exposed to a lot of things that I needed to find out about.
So now you're saying that when you went back to talk to the defendant, you were no longer old-fashioned in your approach to this assessment in this case.
You haven't defined old-fashioned, and
Well, ma'am,
maybe you need to do that for me, or maybe I need to do that for you.
Ma'am, isn't it true that you were the person that used the word old-fashioned during our interview, correct?
Right, but I don't know that you understand what I mean by it.
Isn't it true, yes or no, that you were the person that used the term old-fashioned, correct?
Yes.
And isn't it true that during that time when you used that phrase old-fashioned, you indicated that you were inhibited in your questioning of the defendant?
I said I hadn't asked her if she used KY or not, or
Do you
who
wanna-
brought it, if that's what you're asking me. I did not specifically ask, did you bring KY or did you bring Astroglide? I did not do that.
Ma'am, isn't it true that that's not even, why don't we play it so that you can take a look at it, listen to it, okay?
Objection.
Ma'am, one of the things that you indicated was that there was this issue about Astroglide or KY. Do you remember your response just now?
Yes.
Ma'am, isn't it true that when we were talking about this being old-fashioned, we weren't talking about that. We were talking about something else. And the answer is yes or no. Do you remember?
May we approach? I can't do it without speaking.
Yes, may approach. May continue.
And you indicated that in conjunction with our conversation involving being old-fashioned, something about KY and Astroglide. You said something about that, right?
Yes.
Isn't it true that we were actually talking about something else? Do you remember, yes or no, that we were talking about something else?
No, I don't remember.
And isn't it true that we were talking about anal sex? Do you remember that now?
We were talking about anal sex.
No, I'm asking whether or not you remembered talking about anal sex in conjunction with the fact that you were old-fashioned.
I don't remember putting those together. I remember we talked about anal sex.
All right, well, let me go ahead and play the tape for you, and maybe that will refresh your recollection, okay?
Let's see what is actually on this clip prior to it being played. I see that there's a transcript. I'm just
Yes, you may. Yes. We are going to take one, this will only take approximately a minute, then we'll move on to another area.
Okay.
Did you ever discuss the facts with Miss Arias between her and Mr. McCartney?
She said they had normal sex, and that, and this is once again, I can't recall if it was Bobby Wise or Mr. McCartney that they attempted anal sex once, but that it was, you know, they didn't like it. She didn't like it.
This attempt at anal sex, whether it was consummated, did you say it was consummated or not?
I didn't ask if it was consummated.
Okay, this anal sex, was it at her insistence or his request? Whether it's Mr. Juarez or Mr. McCartney?
I didn't ask.
Why not?
Oh, maybe I'm just old-fashioned. I don't know. I didn't ask because she said she didn't like it.
That was your voice on the tape, correct?
Correct.
And that's us talking about anal sex, right?
Correct.
And that refreshes your recollection as to it, correct?
Correct.
Time, please be back in the designated area at 1:30. 1:30. Please remember the admonition. Have a nice lunch. You are excused. You may step down. You may step down. For the record will show the presence of the defendant and all counsel. The jury is not present. We are completing the hearing we began this morning. The witness has had an opportunity to review Exhibit 604. Ms. Wilmot, you may continue.
Thank you, Your Honor. Ms. Laviolette, you had a chance to review the interview between Detective Flores and Bill Arias,
Yes, I did.
and were you able to view the entire interview?
Yes, I did.
And specifically, you were asked questions earlier by the prosecutor about a 9-second clip of that interview. Were you able to put that 9-second clip into context?
Yes, I was.
And putting that into context, do you see that right prior to that the interview, Mr. Arias is talking about Jodi as a teenager,
Yes.
and that Jodi was in trouble with her parents
Yes.
because she had marijuana,
Yes.
and because she was in trouble, did they search her room?
Yes.
And that after that, is Mr. Arias describing after that that they searched her room, that Jodi felt like they were nosy parents.
Yes.
And after that, she hid things from them, didn't talk to them.
Absolutely.
And then after all of this context we talk about, after that is where we hear the 9-second clip about since she started not talking to them as much, that she basically, the 9-second clip that she lied to them since then, and she was about 14 then.
Yes.
Putting that in context with what Mr. Arias was talking about as Jodi as a teenager, does this make any difference to you in your ultimate assessment of domestic violence?
No, it doesn't.
Does it, something that she did as a 14-year-old girl, as a teenager with her parents, does that have anything to do with or change any of the evidence that you've seen with regard to her truthfulness when you're assessing a relationship between Ms. Arias and Mr. Alexander?
No, it doesn't.
Does it either help or hurt your assessment?
It neither hurts or helps my assessment.
All right, thank you.
Is anything else?
This argument, thank you.
All right.
Irrespective of what Ms. Laviolette say, and with due respect to her position, this appears to be a case where there was shoddy work that was done on her behalf. And one of the aspects of that shoddy work that she did is in taking the defendant's word in this case about the events. There was only one person that she talked to, the defendant, and that was for 44 hours. Gauging or in looking at that statement provided to her by the defendant, this person made the assessment that she was telling the truth. anything that goes to whether or not the defendant was telling the truth is relevant. I understand that she says that it didn't factor into her assessment, but that's not the inquiry. The inquiry is whether or not there's something out there that may be considered or may cast doubt upon her opinion. Certainly the fact that we have evidence already that at that time, around the age of 14, the defendant saw herself as a victim and never was the victim of abuse, according to the evidence that you just received. It's about that same time that this defendant then begins to be dishonest with her father. And it's, even though this witness here says it didn't affect my opinion, that may be so. That may be legitimately what she believes, but her opinion is flawed. And it's flawed because she took the defendant's statements into account without really filtering them adequately for the truth. And so I believe that it is relevant and should come in.
Your Honor, this 9-second clip absolutely is not relevant, and in fact, it's overly prejudicial under 414-2043. The reason being is, first of all, the state is continually trying to characterize or mischaracterize Ms. Laviolette's testimony by claiming that she only took into account Ms. Arias's words during her interviews. That is not the case, and I don't know how often Ms. Laviolette can say it that it's going to change anything, because she keeps continuing to tell the prosecutor that not only did she take into account what Ms. Arias told her, she took into account multiple levels of information, including Mr. Alexander's own words. She also talks about the fact that there is no evidence at the time that she's assessing this domestic violence abusive relationship. There is no evidence that Ms. Arias was being deceitful in any way. In fact, she's talked about the only person who's deceitful has been Mr. Alexander during this time. So, and the second thing was that the state talks about, continues to mischaracterize the evidence that Ms. Arias was not a victim of abuse. There is no such evidence. In fact, the evidence is quite contrary to that she was a victim of abuse as a child. So that state should be precluded from continuing to say that as though it's truth, because it's not. The fact that there is something, this one tiny little piece of information from her father, a father who quite frankly has a motive to not be truthful because he's the one who is abusive, a motive to not paint Miss Arias in a good light because of what he has done to Miss Arias. This tiny little piece of information that we have is not relevant, as you heard, to Miss Laviolette's assessment that she did 14 years later. So the fact that a teenager was not truthful with her parents at some point has nothing to do with whether or not her assessment is flawed. It doesn't weigh. And the fact is the state wants to talk about that there is something out there that could ultimately go to Ms. Arias' credibility. But that's not how the rules work. And the law is, and evidence is weighed, that if there is something that is so long ago in time and so minute in detail, there is nothing to support it other than what this 9-second clip. If it's so minute in detail, that means it's not relevant. And if there is any relevance, it's outweighed by its unfair prejudice. Based on that, I'd ask you to conclude it.
All right. The objection to Exhibit 604 is sustained. However, the state may inquire about the substance in that clip and whether it would have made a difference to this witness in formulating her opinion.
Maybe just have a clarification then as to how the state may inquire so that we don't get outside of your ruling. What is, you're saying that the state may not get into the details, but what is the state allowed to ask them?
Well, the state is allowed to ask if she has viewed this clip and she's aware of the statement made by the defendant's father and if it would have affected her opinion.
So nothing about what the statement of the father was?
Yes.
Okay. All right.
No, he may inquire about the statement of the father, but just not the circumstances that she opined or that the father opined about the defendant's truthfulness and whether that would have affected her opinion.
So he's allowed, okay, so the state's allowed to ask about the father making a statement as to Ms. Arias' truthfulness?
Yes, but not the circumstances.
Well, the problem I see with that, Judge, is that then it makes it sound like it's more important than it is. If the state's allowed to talk about her own father talking about her truthfulness, because it's her truthfulness as a teenager.
It's similar to the restrictions that were placed on this witness with regard to other information she considered informing her opinion. If you're not going to object to the prosecutor putting in the tape or having her explain it, then that can happen. But I believe that the state is entitled to question the witness about this aspect in light of her prior testimony regarding what she considered important in forming her opinion about the defendant's truthfulness or credibility.
Okay, I'm not asking for details, but what I would ask is that it just be qualified so that it's an accurate statement that her father made a comment about her truthfulness as a teenager. So that it's put in appropriate context.
From the state, what do you intend to elicit with regard to Exhibit 604?
I would like to ask
Hold on. Go ahead.
if she has reviewed this clip, that this clip indicates or involves the father, and that the father has questions as to the defendant's truthfulness, and that this statement involves the defendant at the age of 14.
That's fine, Judge.
Okay, let's bring in the jury.
Please stand for the jury.
The record will show the presence of the jury, the defendant, and all counsel. Mr. Martinez, you may continue.
Ma'am, you've had a chance to review a statement by the defendant's father to Detective Flores, correct?
Correct.
And specifically, you have had a chance to review a portion of that statement involving the father's characterization of his daughter in terms of her truthfulness, correct?
Correct.
And there is an issue with regard to her truthfulness with regard to the father, correct, involving the defendant?
Correct.
And this issue that he has with her truthfulness is referenced with regard to the age of 14, correct, and onward.
Correct.
The issue that we discussed previously involving the defendant being a victim, portraying herself as a victim, even though there was no abuse, isn't it?
Objection is mischaracterizing the evidence.
Approach, please.
And in Exhibit 609, we talked about an interview with Zaina Carranzo, right?
Correct.
And she's the one that talks about whether or not the defendant likes to play the victim, right?
Correct.
And one of the things that you told us about this particular incident was that this was when they were teenagers that she was referencing this, correct?
It was actually when she was younger than that.
Well, you indicated previously when you testified that they were teenagers, yes or no?
I thought they were teenagers. I was incorrect.
Well, ma'am, isn't it true that that's what you told us previously? That's all I'm
Yes,
asking.
yes, it is true.
And so this indication that you gave previously that they were teenagers is about the same time that the father made the statement about his daughter's lack of truthfulness, correct?
Objection, foundation, knowledge.
Overruled.
Right?
I gave the wrong age, Mr. Martinez.
I'm not asking you that, am I?
Well, you're asking me to put those
Ma'am.
two things together, Mr. Martinez.
Isn't it true that previously, before the break, and whatever it is that you did during the break, you took,
Objection, argumentative. Sustained.
previous to the break, you testified that this incident involving Zena Carranzo occurred when they were teenagers, yes or no?
Yes, I did testify to that.
And isn't it true that the father's statement about the lack of truthfulness references the age of 14, correct?
Yes, but
I understand that, thank you. Now, ma'am, with regard to certain things, you told us with regard to the interview that you did go back and you did talk to the defendant about certain things, right? Specifically the anal sex, right?
I talked to her about the lubricant.
No, but my question is, do you remember that we played the clip? And
Yes.
the clip involved anal sex, right?
Right.
And you told us before the break, well, I went back and I talked to her about the anal sex, right?
I talked to her about the anal sex.
And so you did go back then and you talked to her sometime afterwards, right?
Specifically about the lubricant.
When you say specifically about the lubricant, you didn't talk to her about the anal sex then?
I talked to her about who brought the lubricant, as you asked me in our interview, who brought that you thought was important, so I went back and asked her about who brought the lubricant for the anal sex.
I'm not interested in who brought the lubricant right now. I'm interested in your knowledge about the defendant's dalliance or activities in anal sex. That's what I'm interested in.
All right.
With regard to that particular activity, did you go back and address that issue with the defendant to get the specifics about that? Or did your prejudices prevent you from doing that?
Objection, argumentative.
Sustained.
Well, you said that you were old-fashioned, right?
Yes.
And did the fact, or was the fact that you were old-fashioned prevent you from going back and talking to the defendant about the various instances of anal sex?
With whom?
With whomever she was having anal sex.
There were different people that she tried. She tried anal sex. She didn't like it. And so Mr. Alexander, as far as I know, is the only person that she had repeated anal sex with.
But my question to you is, did you go back and talk to her about her activities involving anal sex? Yes or no?
I asked her about anal sex.
Yes or no?
Yes, I asked her about
So
anal
you went
sex.
back, and after you went back to talk to her about anal sex, did you talk to her about the anal sex involving all these other individuals, or did you just talk to her about anal sex involving Mr. Alexander?
I talked to her about anal sex with other people.
With regard to those other people, did she ever indicate to you that she had anal sex with Mr. Juarez?
I did not talk to her about Mr. Juarez.
So do you know whether or not she had anal sex with Mr. Juarez?
No, I do not.
Do you know?
No, I do not.
Would it be important in terms of this to see who's assertive, to determine who initiated the anal sex, if she in fact had it with Mr. Juarez? Would that have been important to you?
It's not important in assessing the domestic
answer is no.
violence. It's not important in assessing domestic violence, which is really what I was asked to do here.
So the answer is no. The answer is no, correct?
It would be irrelevant.
Right. And with regard to Mr. McCartney, do you know whether or not she had anal sex with Mr. McCartney?
She said
She said,
that they had attempted anal sex and she didn't like it.
how about with Mr. Brewer? Did you talk to her about having anal sex with Mr. Brewer?
That they were experimented and tried it, and it was not something that either one of them pursued, nor did she pursue it with Mr. McCartney.
But there was at least two, as far as you know, there were 2 attempts at it, correct? Is that what you're telling me?
There were attempts.
Right, I used the word attempt, so there were
Yeah.
2 attempts, correct? And they never went anywhere, I guess is the point. In other words, it wasn't consummated, for lack of a better term.
It wasn't pursued.
And they didn't go forward with it, right?
They didn't continue having anal sex.
Are you saying they only had it once and didn't continue having it?
I don't know how many times they had it. That was not relevant. What was relevant was that it was not enjoyable and they did not continue it as a practice.
And that illustrates that if there's an area out there to discuss and you don't think it's important, then you won't discuss it, right?
If it doesn't feel relevant to the domestic violence aspect of it, because I was retained to look at domestic violence, that's what I did, Mr. Martinez. I looked at domestic violence.
So if it doesn't feel relevant, then it's a feeling that you have about whether or not it's relevant. And if it doesn't feel relevant, then you don't pursue it, right?
If it isn't relevant, I don't pursue it.
You used the word feel. Do you remember just using that?
If it isn't relevant, I don't pursue it.
And the person who makes the determination, the gatekeeper about whether or not it's relevant, is you, right?
In my assessment of domestic violence, I would be the person.
Right. It would be in what you, in your mind, believe is important, right?
What me and my experience believe is important.
Sure. You, your mind, your experience believe is important, correct?
Correct.
It could be that others may disagree with you about what is or isn't important, right?
Yes.
Speculation.
Correct?
It could, sure.
And it could also be that you may be mistaken as to what you think is important or not important, correct?
Objection, speculation.
Right. Anybody can be wrong.
I'm not asking about anybody. I'm asking about you.
Anybody can be wrong.
How about you? Is that a yes?
I'm sure I could be wrong.
And so in this particular case, it could be that with regard to this aspect of the anal sex and who she had it with and how it was initiated, it could be that you could be wrong about its importance, correct?
I don't believe I am.
I know you don't believe that you are, but it could be, correct?
Objection, speculation.
Hypothetically, anything could be true, Mr. Martinez.
But you're saying in this case it isn't, right?
I'm saying I don't believe that it is.
One of the other aspects that we discussed, or that you believe, is that you are aware of the telephone conversation involving the defendant and Mr. Alexander, where they are involved in sex.
Yes.
And you indicated that you listened to that, correct?
Yes.
Did you listen to it before or after my interview with you?
I don't remember.
But you listened to it, and it's your impression that that was tape recorded by Mr. Alexander, correct?
I believe it was tape recorded by Miss Arias.
Do you remember that you and I had a conversation about this interview back in November of 2000 and, I'll give you the exact date,
2004,
November 14th of 2012. Do you remember that we had a conversation about that on November 14th of 2012?
Yes.
And during that time, we discussed your understanding of who had taped that conversation, right?
Yes.
Do you remember that you gave me a different answer?
You've got the paper there.
Yes
I've
or
got-
no? I'm asking what you remember, ma'am. Do you remember?
I don't remember. I don't remember.
So the answer is you don't remember giving me a different answer.
I don't remember giving you a different answer, but I believe that what you've got on that paper is correct, and I could have, because I didn't know everything when I had that interview with you.
Ma'am, you had already formed an opinion when I interviewed you back in November 14th of 2012, right?
I formed a partial
No, do you remember that we discussed it and you said that you already had an opinion? Do you
I had
remember
an
telling-
opinion about domestic violence, and yes, I did.
And in fact, do you know what date this trial started?
Objection, relevance, argument, it is.
Do you know?
What date this trial started?
Right.
It started at the beginning of this year.
No, didn't jury selection, do you know
Well,
that?
jury selection started in December,
Of what year?
last year,
What year? Give us, is it
2012.
Right. And in December, barely a month before this trial was to start, you and I discussed your opinion, didn't we?
In November.
Yes, about a month before this trial was to start, right?
Yes,
And during that time, you gave me all the information that you had at that point, didn't you?
exactly.
So what you're saying is you had already done all of this work. You already had reached your opinion, and yet you then went and did some other work?
I did some other work.
Why is it that when you spoke to me, you already had the impression, or not the impression, the opinion that the defendant was a victim of domestic violence?
Because I had read numerous, in the paper, and I'm not sure which is the IM and which is the text.
You had read material.
I had read a lot of written material. I had looked at a lot of the collateral. I read the collateral data, and I believed I had enough information, but I hadn't read everything. I think I hadn't read some of the text messages or something. I hadn't read everything.
But if you already had an opinion, then what's the purpose of going to continue doing an assessment in this case after after you and the prosecutor had an interview?
Because the more information I can get, the better. And if I find confounding information, or I find something, but the more information I have, the better, to create a better context. So I continue to collect information as long as I can.
So are you saying that when you spoke to the prosecutor in November 2012, you were unprepared to give an opinion as to whether or not the defendant suffered from domestic violence in this case?
No, I didn't say that.
Your opinion was complete when we spoke. You said, isn't it true, that in your opinion, the defendant was a victim of domestic violence, right?
Correct.
And you had reviewed whatever it was that you had reviewed up to that time, right?
Correct.
And you had looked at all of the corroboration that you had taken a look at, right?
Correct.
And based on all of that, you and I had this discussion, right?
Yes, we did.
And it's an absolute opinion that you had. In other words, you weren't waffling when you spoke to the prosecutor about this. You were certain of your opinion back in November 2012, right?
Yes, I was.
If you're already certain about your opinion when you're talking to the prosecutor, what's the purpose of going back? Well, there is no purpose served in going back and doing more work on this case if you already have an opinion, is there?
There is to me.
How can that possibly be if you've already reached an opinion? That's an
Because
absolute.
the more
isn't it?
information I have, the better off I am. The more information I have, it just keeps being helpful to add information. I do that in all my cases. I don't stop gathering information.
Let's talk about the telephone call. That wasn't new information to you at the time that you spoke to the prosecutor in November of 2012, was it?
No,
You knew about it, right?
correct.
And at that time, isn't it true that you told the prosecutor that the person who actually had tape recorded that conversation was Mr. Alexander? Do you remember telling?
That I thought it was.
Well, everything can be prefaced with "I think." Wouldn't you agree?
I don't have a historical record, much like you have right there to refer to. I made some verbal mistakes in my interview with you, and I am more than willing to say that. I'm more than willing to say that I misspoke. It is not information I got from Ms. Arias. I looked at it later because of our interview.
And what you're saying when you're saying that you made mistakes is that you were not paying attention to detail in this case because you were already in the defendant's camp. It didn't matter to you to pay attention to this stuff.
Objection, argument,
Sustained.
Did it matter to you to pay attention to this stuff and be precise about it at that point?
What mattered to me, Mr.
Yes or no?
Martinez, what mattered was context, Mr. Martinez.
Yes or
The
no?
big picture mattered to me, Mr. Martinez. The big picture. All of the evidence. Does the date matter to me? Not as much as what
Objection, not
happens.
responsive.
Sustained.
I'm asking you about a telephone call. I'm not asking you about the date of the telephone call, am I?
No, you're not.
I'm asking about your knowledge as to who recorded it, right?
And I have answered that.
You've answered it, but you've also said that you made a mistake, right?
I made a mistake in who made the recording. Yes, I
And
did.
if you made a mistake about that, something that in your review of all of this case, isn't it true that that is the only piece of evidence that we have where Mr. Alexander is actually present and you can actually hear what he's saying, right?
Where I can actually hear his voice?
Yes.
Yes.
And you're the person that told us that in terms of the clinical interview and people talking, 90% is body language, right? You told us that previously, right?
Right?
If we can't get the body language, at least you can get the inflections from that telephone call, can't you?
Yes.
That's better than looking at a text message where you claim that Mr. Alexander may have been mistaken when he wrote down a name, right?
There are lots of text messages.
Ma'am, we discussed a text message yesterday. Do you remember that? In which
Yes.
you indicated that you thought that Mr. Alexander had written the wrong name. Do you remember that?
Yes.
So this telephone call is much better evidence, if you will, because you can see or hear the interaction between the two of them, right?
That doesn't necessarily make it better. It makes it different, but it doesn't necessarily make it better.
So you would rather have a written document than a recorded conversation, is what you're saying.
I'm saying that a recorded sex tape does not necessarily have to be accurate, any more accurate, but when you look at a compilation, a lot of text messages, a lot of IMs, a lot of Gmails, that you get a lot more information. I'm not denying that it was important to hear his voice and to hear the exchange.
And in terms of the comparative analysis between that exchange between the defendant and Mr. Alexander, the person she ultimately killed, you're saying that that information there is as good or maybe less than as good as something in writing?
Objection is characterized as testimony.
Overruled. You may answer.
Can you repeat the question?
Which is better, this tape recorded conversation or a text message? Which
That's the answer.
Overruled.
one?
I can't say which is better.
In your assessment in this case, you can't say which one is better, right?
I'm saying that there's a large number of text messages. There's a large number of IMs. There is one sex tape that I listen to. So if you ask me to weigh and ask me what's more important, I'd have to say they're important, but I have to take all of that information in.
And that's how you approach this case, where you have something that's as vital as Mr. Alexander talking. When you have Mr. Alexander talking, you can hear in the tone of his voice whether he's happy or unhappy, can't you?
Whether he's happy or unhappy,
Right.
you can hear what he presents, certainly.
Well, it's what he presents, but one of the things that you did is you talked to the defendant and she presented evidence to you by talking to you, right?
Correct.
So now, when Mr. Alexander is talking, he's presenting to you. He doesn't know it, but he's presenting to you, right?
Yes, he is.
And that's even better than what the defendant is presenting to you, because he doesn't have the issue of secondary gain there, does he?
It depends on how you look at it.
Well, no, I'm asking about your definition of secondary gain. Do you remember we talked about that previously? Secondary gain?
I certainly do.
That if it's within the individual's point of view that something is going to be beneficial to them, then there's this issue that they may be deceitful, right?
There's secondary gain in a sex tape.
I'm not asking you about that right now. We're talking about secondary gain, just itself, correct?
Well,
And-
secondary gain is not only part of whether somebody is going to get something from an expert witness or an attorney. Secondary gain also implies what you're going to get when you're having a sexual encounter with somebody.
So you're equating, in this case, an individual who is charged with a very serious crime with somebody who maybe talking about masturbation? You're equating that and saying, well, they both have the same reason to be deceitful.
I did not say that.
Well, that's what you indicated. Are you saying that Mr. Alexander, when he was speaking with the defendant, was in the same relationship as you were with the defendant when you were speaking to her?
If you were in my group, I would ask you to take a time out, Mr. Martinez.
Judge, would you please admonish the witness to
Yes.
withhold those comments and ask that the
Ms.
jury
Laviolette.
disregard the outburst?
Yes. Ladies and gentlemen, disregard the witness's last statement. Ms. Laviolette, please just answer the questions.
Isn't it true, ma'am, that the relationship between you and Miss Arias, when you were asking the questions and you were talking to her, is different than the relationship between Mr. Alexander and the defendant when they were having this telephone conversation back on May 10th of 2008?
Yes, it is.
They were being intimate in that conversation, weren't they?
They were being sexual. I don't know how intimate they were being.
They were being tender to each other, weren't they?
There was a tenderness.
And there was a feeling, if you will, that they were getting along there, correct?
Correct.
There was no indication from the tape itself that Miss Arias wasn't enjoying herself as much as Mr. Alexander, right?
No, there was no indication.
They were both enjoying each other carnally, if only connected through wireless space, correct?
I can't speak to how much someone was enjoying it on a sex tape,
Well,
particularly a female.
I'm not asking about for you to quantify it. There are indications there that Miss Arias is having an orgasm on 2 occasions, right?
Correct.
So she has an orgasm on 2 occasions, and he has an orgasm on 1 occasion, right?
Yes.
So, based on that, it is clear that they're enjoying each other, correct?
Objection, speculation.
Overruled. Have you seen When Harry Met Sally?
I'm not asking you about that, ma'am. I'm asking you whether or not they're enjoying themselves.
I can't tell whether she's having an orgasm or not.
So that
I can
means
tell that she's...
So that means then you can't tell if he's having an orgasm either, right?
No.
So you're saying that, as you said here, they may have had an orgasm or they may not have had an orgasm, right?
They were at least acting like they had an orgasm.
Both of them were acting, right?
Yes. They were acting as they had an orgasm. I don't know what they had.
But there's really no indication from any collateral source that, for example, the defendant was not having an orgasm. You don't have any information from any other source that says she wasn't, right?
No, I don't.
You don't have any information from any other collateral source that says he wasn't having an orgasm, right?
No.
So why is it that you are now choosing to interpose a belief that, for example, Mr. Alexander was not having an orgasm if there is nothing out there to support that?
Objection, argumentative.
Sustained.
What leads you to believe that Mr. Alexander was not having an orgasm?
You know, once again, my expertise is in domestic violence, not in orgasms.
Then
And-
why did you answer the question the way you did if you're not an expert in orgasms?
Because you ask me questions so quickly, and I really should stand back and think about them, because those questions are not within the sphere of what I actually was retained to do, which was assess domestic violence.
Or it could be that, as you sit out there, you're advocating on behalf of the defendant and you're only presenting things that benefit her.
Objection, argumentative.
Correct?
It was
This conversation where they are both talking, you told me that you believe that it was Mr. Alexander that tape recorded it, correct?
Correct.
And that's because of your biases and because you were, if you will, in favor of the defendant, that would seem more appropriate to you, correct?
No, I just misspoke.
You just misspoke, but you had no basis for misspeaking, correct?
Probably, I did not.
You could have properly said, I don't know, correct?
Yes, I could have.
But instead you chose to cast aspersions, if you will, on Mr. Alexander.
Objection is characterized as the evidence as casting aspersions just because he
Overruled.
recorded it or not.
You may answer.
I didn't believe that was casting aspersions. I believed that I didn't believe whoever taped it was a problem. I believed that they were both participating, so I didn't think that was problematic that he would, whether he did it or whether she did it.
Just like the text message before that we discussed that involved the names of those two women. Do you remember that we discussed that yesterday?
Yes.
Rather than saying, well, it could be that the defendant lied to Mr. Alexander, you immediately went to the fallback position that Mr. Alexander perhaps typed the wrong name. Do you remember telling me that yesterday?
Yes.
Every time that there's been a judgment call in this case, you have taken the defendant's side, correct?
I'm not sure that I have.
Well, on those two occasions you did, right?
On 2 occasions I did. And I don't think of it as taking someone's side because I don't think that who taped the thing was a critical issue. I didn't think it cast aspersions on either Mr. Alexander or Miss Arias. I just thought they consensually did a sex tape and that wasn't a really important aspect as to who did it. And I probably just should have said, I don't know.
Well, you had information previous to that the defendant really only had sex with Mr. Alexander to please him. You've had that information, didn't you?
No.
That you never heard that the defendant felt uncomfortable when she was engaging in sex with Mr. Alexander?
And I also heard that she felt comfortable.
Foundation, when?
Sustained.
As part of your investigation in this case, did you review several sexual encounters involving the defendant and Mr. Alexander?
Yes.
And with regard to the first sexual encounter, what is your understanding of the first sexual encounter? What kind of sex act was involved?
It was oral sex, and she was uncomfortable with it being too soon.
Ma'am, so it was oral sex and she was uncomfortable with it being too soon. Where did this oral sex take place?
The oral sex took place in the home of the Hughes.
And that's the first time that they ever had this oral sex, right?
Yes.
With regard to this oral sex, you said, well, she felt uncomfortable, right?
Yes.
So if we then listen to the tape, was there any indication there that she was uncomfortable with any of the phrases that were being used?
Objection is the foundation when the tape was actually made.
Approach, please. Overruled, you may continue.
Your assessment of the tape, you don't see anything indicating that the defendant is uncomfortable in any way, do you?
You mean 7 months later?
No, I mean on May 10th of 2008. So,
Seven months after she said she was uncomfortable?
all right, if you want to say 7 months after she was uncomfortable, let's go with 7 months. Yeah, 7 months after she was uncomfortable.
I don't see discomfort in the tape of 510, if that's what you're asking.
And ma'am, just for the purposes of the math here, if that happened in May of 2008, would you agree then that 7 months before that would be November of 2007, correct?
Correct.
And
No, I'm sorry. November.
so
It
that-
was November of 2006 when they first had the sexual encounter, so it's quite a bit prior to that.
part of the reason that I point that out is that it appears that you seem to jump to a conclusion when you're answering these questions, and like in this case, you were mistaken. Wouldn't you agree?
Objection, argumentative.
Overruled.
That I gave the wrong date, the 7 months?
You were mistaken, weren't you?
Yes, and I remembered quickly that it was November 6th.
No, you didn't remember quickly. Actually, the prosecutor prompted you, correct?
Objection, relevance, argumentative.
Overruled.
Isn't that how it worked?
I didn't feel prompted by you, but okay, if you want to prompt me, that's fine.
Didn't the prosecutor indicate to you May 2008, and just for purposes of clarification, he then indicated it was November 2007. Do you remember that exchange?
And
just
then,
now?
yes, and then I said.
Yes or no?
That,
Yes or no?
I said.
Thank you.
Yes.
Thank you. Now, ma'am, one of the other things about the interview that you had with the defendant is that you had these issues with regard to what she told you, but you also prompted her with leading questions, didn't you?
I don't believe I did.
You suggested some answers, didn't you?
Objection, foundation, debate.
Are you talking about?
Objection overruled. You may answer yes or no.
I don't, I mean, I interviewed her over 44 hours, so I'm not sure. I try very hard not to lead people.
Well, do you remember that with regard to her, one of the things involving sex was that you had an issue or a question as to whether or not the defendant or the defendant, yes, isn't it true that you wanted to know from Miss Arias whether or not she used sex to quell his anger? That is your question, right?
Yes.
And those are your words, right?
Yes, but I think she had already mentioned that to me. And I was
Well,
just,
if she had already mentioned it to you, then why did you feel the need to ask her about it?
you know, that was a long time ago.
Well, then maybe we
I
can-
don't know. I really don't know. I can't tell you.
Let's take a look at your notes about what you wanted to ask her.
All right.
Objection, judgment, for argument.
Overruled.
Take a look at Exhibit 612. You recognize the writing there?
Sure.
That's your writing, correct?
Yes, it is.
And at the top of the page, it indicates ask Jodi, right?
Yes.
These are the questions that you wanted to ask her, correct?
Correct.
And in fact, there are more than one or two questions there, correct?
Yes. Yes, there are.
And none of these questions, if you will, have a question mark after them, do they?
No, I guess not.
Well, no, let's just take a look at the first one and read that. And, well, just read the whole document to see there are no question marks.
No, there aren't any question marks.
But you do say that you want to ask Jodi about this, correct?
Correct.
This is part of your investigation into this case, right?
Yes.
And one of the things that you wanted to ask Jodi was, did you use sex to quell his anger, right?
Yes.
So that was your, if you will, question to the defendant, correct?
It was my question.
Yes. And so you were leading her or suggesting the answer there, weren't you?
I didn't feel that I was.
I know you don't feel that you were, but isn't it true that you're saying, did you use sex to quell his anger, right? You're speaking specifically about anger in that question, right?
It was after.
You may. Continue.
Isn't it true that you were suggesting the answer there when you were talking about anger?
I was basing it on information that I had gotten from journals and other information, and I was putting it together, and I was asking the question because it appeared that that was happening.
So the answer is...
So I did ask that question. I did ask that question.
Isn't it true then that you did suggest the answer of, did you use sex to quell his anger? You suggested an answer there, right?
I guess I did.
And you also asked whether or not distress to Travis means sex, right?
I believe that might have been an answer and that was an answer to that question, not a question.
Actually, that's not the way it's written. Take a look at the way it's written.
It said distress to Travis meant sex. I think that is the answer to that question.
And at the top of this page, it also says ask Jodi, right?
Right, but
Yes or no? It does say that at the top, right?
they weren't all questions. I do sort of stream of consciousness, so I ask Jodi questions, I get answers, I might put them on the same page. I just want to clarify that.
How is it that you are saying that you are putting some other questions on this page, other answers on this page, when they're clearly all questions here?
Objection, mischaracterizes her testimony.
Oh, you may.
Right under, did you use sex to quell his anger? I have an answer, distress to Travis meant sex. That was an answer to that question.
So you provided your own answer to the question then. That's what you're saying,
No,
Mischaracterizes her testimony.
Oh, you may.
right?
it was a question I asked Miss Arias, and so I write on the papers that I write questions on, I write answers on, I write other things on. So it's not clearly just all questions, it's not clearly just all answers. I intersperse things.
Ma'am, isn't it true that at the top of this page it says ask Jodi, correct?
Correct,
And then there are a number of writings underneath there, right?
correct.
You're not saying that as you're sitting there talking to the defendant, you're writing down ask Jodi, are you?
No, I'm not.
This is something that was done in advance, isn't it?
The question was, yes,
This document was done in advance, wasn't it?
yes.
And so when you say that, well, I write the responses, how could the responses be there if you're doing this document in advance?
I wasn't doing all the, Mr. Martinez,
Yes or no? Yes or no? Isn't it true that all of these questions were written in advance?
Judge, the original question was not a yes or no question. Or did not request a yes or no answer.
All right. Your objection is noted, overruled. You may answer the question.
the question is correct.
Thank you. Thank you. Now, one of the other things that you told us is that you reviewed all of the, or a lot of the defendant's journals, right?
Yes,
And that these journals, if you will, were guided by this law that she believed in, that if you, when you write something in there, that you should write something positive and not anything negative, correct?
that you should try to focus on the positive.
Right. And what's that law called again?
The law of attraction.
So this law of attraction, according to you, the way that, and you've had some information that you received upside and apart from what the defendant gave you, correct?
Well, I watched The Secret. That's it.
So The Secret is a movie, right?
Correct.
And in it, it talks about, or it is about the law of attraction, right?
Yes, and says there's a documentary, and I don't remember the name of that.
But you didn't watch the documentary, correct?
No, I watched the documentary as well.
Oh, you did. And then you also spoke to the defendant about the law of attraction, correct?
Correct.
And that is what encompasses your knowledge of the law of attraction, correct?
Correct.
And the law of attraction, as you've defined it for me, is that if you write something positive, positive things will happen, correct?
No, it's not that simple.
Go ahead and tell me what you believe the law of attraction is.
That's part of it, that the energy you put out in a positive way comes back to you. So you should think in a positive way, write in a positive way. And this was a documentary done by physicists, and they were talking about positive energy and all of the energy, the energy coming back to you.
And one of the things you just mentioned to us is writing in a positive way, right?
Correct.
And so, for example, this is what you applied in reading the defendant's journals, that she was influenced by this law of attraction, correct?
Correct.
And so that, according to you, she wouldn't write anything negative in that journal because it would go against the law of attraction, right?
No, I didn't say that.
Well, isn't it true that we talked about, or you talked to the defense counsel about situations as to whether or not there was anything negative about Mr. Alexander? Do you remember talking about that?
Yes, and there were several things
yes.
that were negative.
And you also were asked about certain events that occurred in their life. For example, when she alleges that he hit her. Do you remember that?
Yes.
And you said, well, because of the law of attraction, it made sense to you that those wouldn't be written in the journal, right?
Yes, I believe I don't think that's the only reason, but yes.
That's part of the reason. And,
Sure.
and based on what you know about the law of attraction, you would not expect her to write anything negative in her journals because it would be contrary to that law of attraction, right?
No, I would expect that even when you have a philosophy of the law of attraction, that you're not always able to maintain it.
Okay, so in this case, though, with regard to writing negative things, you did not find anything in those journals indicating that Mr. Alexander ever laid a finger on the defendant, correct?
Objection is characterized as testimony.
Overruled. You may answer.
Correct?
Correct.
But you still believe the defendant, though, right?
Based on other things.
And those things are her statements, right?
Those things are Mr.
Well, no. Let's do this. You believe it in part because of her statements, right?
In part.
You also believe it in part because of the law of attraction, right?
I believe that she didn't write in it because of the law of attraction, or I believe
That she
he
was-
never laid a finger on her.
You believe that the reason she didn't write these things in her journal, as you explained it on direct examination, is because, in part, she's an adherent to the law of attraction, correct?
Correct.
And that's how you went behind, if you will, the written word, correct?
Objection recommended.
Overruled.
I believed that that was a reason she didn't write in her journal.
Right, and that's why you went behind the words that indicated otherwise, right? The words never indicated that he ever hit her, correct?
Correct.
The words never indicated that he ever choked her, correct?
Correct.
The words never indicated any other physical act towards her, correct?
Indicated cruel behavior, but I don't know
Acts.
what that was. I don't know what that meant.
I'm talking about acts. For example, did they
Cruel
never...
behavior would be an act.
With regard to that, there was no indication that he ever hit her. Where is your understanding that he hit her on the day that she indicated that she was leaving?
I have no indication other than her word.
Right, and what did she tell you?
On the day she was leaving, wait a minute, on what day that she was leaving?
Remember that you talked about the Mr. Alexander hitting the defendant on the day that she indicated she was going to move back to Wairika.
Correct.
Where did he hit her?
He hit her on the jaw, on the...
And you got that information from the defendant, correct?
Correct.
Do you know somebody by the name of Dan Freeman?
Yes.
And you're
Well, I don't know him. I just read a statement. I don't know him.
And with regard to Dan Freeman, you know that he's somebody that's a friend to the defendant, right?
Correct.
And in that story that we're talking about, the one where she tells him she's going to go to Wairika, and there's this, it appears to be a backhand, correct?
Correct.
He strikes out and lashes at her because he doesn't want her to leave, correct?
Correct.
Objection, speculation as to Mr. Alexander, his reasoning behind hitting.
Sustained.
Well, isn't that what the defendant told you? That Mr. Alexander hit her because she told him that she was going to go to Wairika.
And that he was upset about it.
Right. That's what she told you, right?
Correct.
Again, my question to Dan Freeman, do you know whether or not Mr. Freeman had a conversation with Mr. Alexander prior to this incident about whether or not Mr. Alexander wanted Miss Arias to even be around in the Mesa area?
I have no information on that.
Would it be important to get that side of the story if, hypothetically speaking, Mr. Freeman were to have testified that it was actually Mr. Alexander that had to have the talk with the defendant about breaking up and leaving?
That would be information that I would like to have.
Let's assume that that's the hypothetical, that Mr. Alexander actually didn't want anything else to do with the defendant, and he's the one that's pushing her away and telling her to leave.
Objection is characterized as testimony.
Let's assume that. And assume that it's Mr. Alexander that's telling her that he wants her to leave. Wouldn't that be something that you would want to know in weighing whether or not what the defendant told you is true involving her statement about telling Mr. Alexander that she was going to Wairika?
It's important, and I have no evidence to support what you're saying.
Right, but let's assume hypothetically that that evidence does exist out there. I'm asking you to assume the truth of it. Assume
Well,
that
you're asking me to assume a hypothetical that I have no evidence of. Is that correct?
and I'm assuming that, and I'm asking you to assume that hypothetical because that person, let's say, came into this court and said that.
All right.
Assume that. If all of that were true, wouldn't that cause a problem in your assessment of this case? Because now, at least, as to this alleged incident, it doesn't seem to be true.
It would be important for me to have that information.
You have that information. Now what are you going to do with it?
What am I going to do with it?
Yes, in terms of your opinion, does that give you a sense of pause in the firmness of your opinion?
It gives me information that I have to look at, that I have to check out. Does it globally change the picture of domestic violence in regard to the evidence that I have reviewed and seen? It doesn't mean that there was no domestic violence.
So what you're saying, your opinion that changes not, even though you have that new information were to be provided to you, right?
That Mr. Alexander wanted Miss Arias to leave?
Yes, and go back to Wairika.
There's also no evidence of that.
I'm not saying that there's no evidence of that. I'm asking you to assume that Daniel Freeman came into this courtroom and said that he was there. If you had that, would that give you pause in terms of your opinion?
I would,
Yes or no?
it's not a yes or no question.
Okay,
Mr.
then we'll move on.
Martinez.
Now, with regard to this fight, do you remember about that you told us about the trip to Havasupai?
Correct,
And you spoke to the defendant about it, right?
correct.
And what was her version of the trip to Havasupai? Why don't you tell us what you know about the trip to Havasupai and tell us who started it, if there was a fight?
There was an argument
Between whom?
between Miss Arias and Mr. Alexander.
Where did it start?
I don't know where it started.
Do you know how it started?
I read two things. I read
Sure.
something that the Freemans wrote, but I would like to look at the information in
Well,
the journal, because I got the information from a journal that I read, and the specifics of that information. I can tell you the gist of that information.
Why don't you give me the gist of that information?
The gist of that information was they had a fight, they had an argument. In fact, Lisa Andrews said he was very negative, that she thought he was overly negative reporting that trip. According to Miss-
I'm just asking about the trip itself. I don't want all this collateral information that you want to provide.
Okay.
I want to know, for example, who started the fight, what was said during the fight, how long the fight lasted, and whether or not the defendant made any comments about the fight in her journal. That's sort of the information that I'm looking at.
Objection, Judge, he just asked for the gist. If he's going to go into detail, then the witness is requested to be able to review the document.
All right, we're going to take the afternoon recess at this time, ladies and gentlemen. Before I release you for the afternoon break, the court is considering holding trial on Friday, this Friday, April 12, from 9:30 to 12:30. I'm also considering holding trial on April 26th, that's a Friday, from 9 to 4, and on May 3rd, from 10 to 4. During the break, please look at your calendar, and when you come back, I'm going to ask you to let me know if any of those dates would cause a problem for you in being present. Yes. Yes. April 12th, 9:30 to 12:30. April 26th, from 9 to 4. And May 3rd, from 10 to 4. In addition, for your planning purposes, one of the jurors has a conflict this Thursday, so we will be starting trial at 10:30 instead of 9:30. So 10:30 this Thursday. And I know there is a request by another juror for 2 additional days. We are still discussing that. Any other questions about the schedule at this point? All right, you are excused. Please remember the admonition. Of the jury, the defendant and all counsel, Mr. Martinez, you may continue.
Ma'am, I want you to take a look at exhibit number 242.001 and go to the entry dated Thursday, September 13th, 2007. Read it. If you're done reading it, you let me know.
September 13th, did you say?
I have it tabbed for you right there. See it? Let me do it again. Here.
I'm sorry. Okay.
Are you done reading it?
Yes, I am.
Why don't you just turn it the other way with the binding up and then down. Well, that's all right. Anyway, with regard to that, that is something that you read as part of your investigation into this case, right?
Correct.
And it's something that you remember reading, right?
Yes.
And it is something that you used in reaching whatever assessment you reached in this particular case, right?
Yes.
And one of the things that that talks about is a trip to Havasupai, right?
Correct.
And it references a number of people going with them to Havasupai, correct?
Correct.
It's the defendant who goes, one of the people, right?
Yes.
One of the other people is Travis Alexander, correct?
Yes.
Somebody by the name of Daniel Freeman also goes, correct?
Yes.
And Desiree Freeman, right?
Yes.
And there's some writing there, and this is written by the defendant, correct?
Correct.
That's your understanding of it, right?
Yes.
And this is part of the corroboration that you used in reaching your assessment, right?
Yes.
In other words, this is a collateral source that you found to be, for lack of a better term, accurate, so that you could then compare it to what the defendant was saying and to what other people were saying, right?
I didn't consider this a collateral source.
So it's a primary source then, right?
It's a source from the defendant.
So you consider that to be a primary source then, right?
No, I look at collaterals as just other people other than the defendant. Not that it's better or worse, but that it's
And in
direct.
this particular entry, the defendant bemoans the fact that things did not start out very well on the trip to Havasupai, correct?
Correct.
And she indicated there were some tense moments there at the beginning, right?
Yes.
And then she also indicated that Mr. Alexander apologized to you, correct?
Correct.
And she said that, according to her, that he was 90% responsible for the argument, right?
Yes.
One
That
of
he
the other
said he
people-
was. Yeah.
Pardon? What did
She
say?
says that he said he was 90%.
Right.
Yeah.
Not the gist of it. He's saying that he's 90% responsible for the argument, right?
Correct.
And did you consider talking to Daniel Freeman about that incident to see if it actually corresponded to what's actually in that book?
I read the Freeman statements, but
So the answer is no, you did not talk to him,
I
correct?
did not talk to him.
And that being the case, you are left with that rendition there as something that, in your view, since it's a primary source, is something that's truthful, correct?
It's something that I took to be truthful, yes.
Right. And if it's truthful, though, would it cause you to reevaluate how you viewed all of these entries in the journal if it were found that perhaps that entry was not accurate? Would it cause you any problems?
Is this a hypothetical?
Let's assume that it's a reality and that whatever's out there indicates that what's in that journal is not accurate. It's not, you took it to be truthful, now find out that perhaps that's not what happened. Would that cause you any problems?
Sure.
And it would cause you problems with regard to all the other entries, right?
Depending on what I had collaboration
Sure.
to defend.
But if you only had the journal entries and one of them turns out to be untrue, it could then be, if you will, a cancer that is spread throughout all of these journals, right?
Objection is mischaracterizing this journal entry as untrue, making it as a statement rather than an hypothetical.
Overruled. You may answer the
Go ahead.
question.
If I'm assuming this is untrue,
Right.
that it would make me look much more carefully at the other journal entries and look to the other collaborative sources.
And wouldn't it cast doubt then on whatever statements the defendant gave to you if they corroborated that, right?
If they corroborated,
What's in that journal right now?
I would look at all my corroborating data, Mr. Martinez.
Did you talk to the defendant about that particular trip to have a suit by?
Yes,
And she told you that what's in there is correct, right?
correct.
So if, for example, in this case, Daniel Freeman came in and testified and indicated something different than that, that would be problematic, wouldn't it?
Objection is characterized as Mr. Freeman's testimony.
Overruled, let me answer the question.
Is this hypothetical? Because I have no evidence of this.
Right, you were not here when he testified. But
No.
assume hypothetically that he said something different.
If you propose a hypothetical
Well,
that I have no evidence of, you want me to say what I
Right.
think about that hypothetical
Sure,
I have no
sure.
evidence of.
Assuming that that person came in and testified to that in this courtroom, hypothetically, all right?
Yes,
Under oath, all right?
yes.
What if Mr. Freeman came in and testified that the fight was actually started by him? I want you to assume that.
Objection is characterized as Mr. Freeman's testimony.
Overruled.
Assume that. Can
I
you do
don't,
that?
Miss Arias does not say that Alexander started the fight. Just that they had a fight.
I understand that. Assume that it was Mr. Freeman that started the fight, correct? Can you assume that for me?
I can.
And assume that there was an argument because of something that Mr. Freeman did, correct? Can you assume that for me?
Okay, you're asking me to make a lot of assumptions based
Yes.
on information I don't have.
Absolutely, that's what I'm doing. Can you do that for me?
I can go along with that.
And assume those two facts, just those two facts. Those aren't written in that September 13th, 2000 entry, is it? 2007 entry, are they?
No.
And if they were true, wouldn't that make that entry incomplete?
No, not necessarily. I mean, it's
You
not a
wouldn't-
detailed entry. It's
Well,
just a,
Aren't you providing an excuse and aren't you siding with the defendant again, saying, no, it wouldn't make any difference what this other information that you gave me?
no, I'm not saying that.
Sustained.
Aren't you not looking at both sides equally when you say to me, well, it wouldn't matter, in this case, those two facts that you've added?
What I'm saying is that I try to look at the big picture.
I understand you want to look at the big picture, but...
And that this particular
Ma'am, I want you to
entry-
look at the small picture, September 13th of 2007. It's-
No. Next question.
Look just at that entry. You don't want to talk about any other entry, please.
All right.
With regard to that entry, if you found that it was incomplete and didn't include the reason for the fight, wouldn't that be important to note?
It doesn't include the reason for the fight.
I know it doesn't, but wouldn't that indicate that it's incomplete because it doesn't indicate the reason for the fight?
It's just a journal entry.
And that journal entry means nothing to you, does it? Or it does?
A standalone journal entry
Yes.
doesn't mean as much to me as when I look at the big picture.
I'm just talking about this one, and I understand what you're saying.
It's incomplete, I will agree with that. There's not any description of the fight or anything.
So if it's incomplete with regard to that, and you're relying on it, it would appear that you're relying on something that's incomplete, correct?
I'm not sure that you're looking at how I rely on things.
Well, you read it, right?
Yes, I did.
You put it into your brain, this brain that you use to go through this continuum of aggression, right?
Objection argumentative.
Overruled.
Right? You put that information, after reading it, assimilated it into your brain, and then made a decision based on this continuum of aggression that you talked about, right? That's what it's part of what you did with regard to that, right?
I told you the way I used the continuum. So I'm not putting it into the continuum. I'm putting it into the big
All right, so you took this,
barrel of information that I've gotten.
so you took this entry and you put it into this big barrel of information that you have, right?
Correct.
What if that's a cancerous, if you will, or invalid entry that you put in with the other information that you have there? That won't affect your view or opinion in this case?
Objection, assumes facts, not evidence.
Overruled. Anything can affect.
All right, specifically here in this case, we both agree, or you agree, that the reason for the fight is not there, correct?
Correct.
And so that's an omission on the writer's part, correct? To put that in there. For whatever reason, the writer didn't put it in, right?
Correct.
You don't know the reason why the writer didn't put it in, correct?
No, I don't.
It could be that it would reflect badly on the writer, right?
Objection, speculation.
Sustained.
Well, with regard to this case, assume that Mr. Freeman came in and testified that the reason that the fight started was that because the defendant was being unreasonable as to the items that she was going to take on the trip. I want you to assume that.
Objection is characterized as Mr. Freeman's testimony.
Overruled.
Assume that. Will you do that?
So once again, you have me assuming
Yes.
facts I have no knowledge of.
Absolutely.
And no evidence for.
Not no evidence. You don't have any information of it. That's what I'm saying.
Yeah.
Correct? You weren't here when Mr. Freeman testified, were you?
No, I was not.
So assume, for purposes of looking at that journal entry, that the reason the fight started was because the defendant was being unreasonable as to the items she was going to carry on this trek. Assume that.
Objection. Mischaracterizing the testimony of Mr. Freeman.
Overruled. This is a hypothetical.
Assume that.
Judge, I would ask that it be placed as a hypothetical and not that Mr. Freeman came in and said those things.
Sustained.
Assume the hypothetical that I just gave you, please.
Okay.
All right? Assuming that. Wouldn't that cast doubts on the validity of that entry?
Yes.
And additionally, also assume, ma'am, that with regard to this fight, whatever it was, that this fight then escalated at some point and they went somewhere else, the two of them. Assume that. Can you do that? A different part of the house. Assume that, hypothetically speaking.
All right.
It doesn't talk about them going to another part of the house in that entry, does it?
No, it doesn't.
It doesn't talk about what happened at the other part of the house in that entry, does it?
No.
And it doesn't talk about what was said between the two people, if anything was said, when they were in that room, does it?
And this is all hypothetical?
Hypothetically.
Hypothetically, you're giving me a lot of things that I don't have any reason to believe, but I will go with a hypothetical if that's what you want.
Well, does it say anything there about anything happening in a bathroom?
No.
Does it say anything in that entry about anybody cursing at anybody else?
No, it does not.
Does it say anything else about how that argument was resolved, if it was resolved at all in the bathroom?
No.
So you don't have any information. That entry is an example of something that is very incomplete, right?
Yes.
And so did you talk to the defendant about this?
I did talk to the defendant about it, but I'm not recalling all the details. I'm recalling that there was, I'm recalling some of the things that the Freeman said and some of the things that Ms. Arias said, but I would need to look at the Freeman's statements about this particular.
That's not my question. Isn't it true that you talked to the defendant about this? That was my question, yes.
Yes, I talked to the defendant.
And you discussed this particular entry with her, right?
Yes.
And even though you discussed this with her, and even though you had the Freeman statement in front of you, whatever that statement may be, you still found there was nothing invalid about this particular entry. In other words, it's something that you found according to your gatekeeping abilities. You found that one to be true, correct?
I found it to be one piece of information that I didn't put that in the, if you're looking at it and saying, did I put that in the mix with domestic violence? No, I didn't.
I'm not asking you that, if you put it into the mix with domestic violence. Are you clear about that?
No, I wasn't clear about that.
I'm asking because you say that you take the items and you look at items that you think are truth, and then you decide to do something with them. Did you decide that this was either truthful or untruthful, given the way you approached this?
I decided that it wasn't incredibly important, but did I believe it? I thought something happened and that there was an argument, and that I believe that Mr. Alexander apologized. Yes, I did.
I'm not asking that question specifically. You read the entry for September 13th, 2007, right?
Yes, I did.
And it's the written version, correct?
Correct.
I'm asking you if you believe the written version in that exhibit. Yes or no?
Objection, asked to be answered.
Overruled. Did I believe
Yes.
the limited information that was given there?
Yes.
Did I believe there was an argument?
No, I'm not asking you that. I'm asking you about that black item that's to your left. Do you see that?
Yes, I see
It's
that,
a
but I'm
book.
not.
Ma'am, let me do it this way. It's a journal, correct?
Correct.
In that journal, it's an entry for September 23, 2007, right? September 13th, 2007, right?
The 13th,
Right.
not the 23rd.
Right? This is 13th, correct?
Yes.
Do you believe that entry for September 13th, 2007, in that black book that's to your left? Yes or no?
Do I believe
The truthfulness-
that it was just, do I
No.
believe there was an entry that said, I'm not sure what you're trying to get here.
Well,
I'm not
ma'am,
sure.
you say that you evaluate what's being told to you for the truthfulness. Didn't you just tell us that earlier today?
Yes.
I'm asking you to tell me, based on your statement that you evaluate things for the truthfulness of it, I'm asking you to tell me whether, after conducting this evaluation for truthfulness, you find that to be truthful or untruthful. That's all I'm asking you.
Objection, can we approach?
Yes, you may approach.
Yeah, the entry is September 13th, 2007. You've read it, correct?
Correct.
Do you believe everything that is written in the entry of September 13th, 2007?
Do I believe everything?
Yes.
I believe the essence of it.
No, I'm not asking whether or not you believe the essence. I'm asking whether or not you believe everything that is written for the entry of September 13th, 2007.
Objection, asked to be answered.
Overruled. I believe that
Is that yes or no, ma'am? And then you can explain.
I basically, yes, I have no reason not
All
to
right,
believe
thank
it.
you.
Okay.
Now, one of the things that you told us in taking a look at the defendant's journal was that you saw no evidence of jealousy, right?
Correct.
And that would assume that if you saw no evidence of jealousy, was that all of the entries would be complete and truthful, correct?
Not necessarily.
Well, if some entries were incomplete and untruthful, wouldn't that cast doubt on the completeness of the writings?
Yes, it could.
And so in this case, though, you took a look at all of the journals and all of the writings in the journals, and in response to a question on direct examination, you said, I saw no evidence of jealousy, correct?
That wasn't just about the journals, Mr. Martinez. That was about the other evidence as well.
Right. Assume that you looked at, fine, you looked at the other evidence too, correct?
Correct.
Well, part of what you used to look at was the journals, right?
I did use the journals as well.
And I want you to focus on the journals only for the purposes of my next questions, correct?
Okay.
And this is the journal that has this law. Whenever the defendant writes, she applies this law, correct?
The law of attraction.
Right, the law of attraction, correct? So that she wouldn't put anything negative in there, right?
She did put some negative things in the journal.
I know that you indicated that she did put some negative things in the journal, but she didn't put anything about Mr. Alexander hitting her, correct?
Right.
Didn't put anything about Mr. Alexander choking her, correct?
Correct.
Didn't put anything of any physical violence from Mr. Alexander to her, correct?
Correct.
Didn't indicate anything about this masturbatory incident to photographs in the journal by Mr. Alexander, correct?
Correct.
So if you look at these journals, they're incomplete the way you view them, right?
Yes.
And you view them as incomplete because it's your position that she didn't want to write anything negative in there because in part of the law of attraction, right?
In part.
So she was censoring herself as she was writing things in there, right?
Apparently.
Well, no, that's what you believe though, right?
I believe she censored herself. Yes.
Right, and in censoring herself and applying the law of attraction, wouldn't it also be fair to say, if we were looking at the other side of the coin, that in terms of the question involving jealousy, that she probably was jealous and she just didn't write it down, right?
I have no evidence that she was jealous.
I know you have no evidence of that, but because of the law of attraction, she's not going to put down something that is negative. That would be negative energy to say, I'm very jealous of Mr. Alexander with all these women. That would be a negative thing under the law of attraction as you know it, right?
Saying that you're jealous would not necessarily be a negative thing.
Writing it down. We're talking about the written word, right?
Saying that she was jealous would not interfere with the law of attraction. Saying that maybe she wanted to handle the jealousy, that would be, she could do that within those parameters.
So being jealous, incredibly jealous, that's a good thing,
Objection is characterized as your testimony.
Overruled.
right?
I didn't say that.
Well, that's my question. Isn't it true that being jealous is a negative thing with negative energy associated with it, right?
Correct.
You see that in your business all the time, don't you?
I see what?
Jealousy in
Yes, I do.
couples that you counsel, don't you?
Yes, I do.
It's a real negative emotion, isn't it? In the people that you counsel, right?
It depends.
Well, okay, so it's positive in some of the couples that you counsel.
No,
Jealousy.
it's not a pattern in some of the couples that I counsel.
I'm not asking about pattern. I'm asking about the emotion of jealousy. In your experience, isn't that a negative emotion?
It's a human emotion.
But it's a positive emotion then. I'm asking you to put a perspective on it for me. Do you view it as somebody who does this forensic evaluations in domestic violence? Do you view it as a positive emotion, jealousy?
I view it in regard to the behavior it generates. So if it generates negative behavior, then it becomes negative. It's an emotion. An emotion in and of itself doesn't have to be particularly negative unless there is very negative behavior associated with it.
Give me examples where jealousy generates positive things from it. Give me an example.
There are people who get jealous And out of that jealousy, they step back from it, they figure it out, they then approach the person in a positive way.
No, you're talking about treatment. I'm not interested
No,
in
I'm not
treatment.
talking about treatment. I'm talking about what people do with jealousy.
Right. I'm not asking you what people do with jealousy. I want you to tell me a situation, for example, where a woman is very jealous of a man. Tell me, in that circumstance where a woman is very jealous of the man, of all the couples that you've treated, where that woman has done something positive so that we can hold jealousy as a virtue right up there with love.
Objection argumentative.
Sustained.
Give me an example of someone who is afflicted with this incredible jealousy where they do positive things with it.
You're talking about two different things. You're talking about someone who's afflicted with jealousy and someone who has become jealous. Those are very different things.
Let's assume that the defendant, you can't tell us that the defendant was not afflicted with jealousy, can you?
I can tell you I have no evidence in collateral data that she is, and not just in her journal.
Well, I'm talking about the journal. If the defendant were afflicted with jealousy, that would be a negative energy kind of thing in violation of this law that she subscribes to. Yes or no?
What do you mean by afflicted?
What do you mean by afflicted? Isn't that the term that you used just now?
No, you used the term afflicted, and I'm
You
feeding
didn't,
it back to you.
You didn't say a person is afflicted with jealousy?
I said it after you said it.
You believe that I was the one that started this then? Okay. There are two types of emotions with regard to jealousy. Do you remember describing them to me just now?
I said there's a difference in a pattern of jealousy, and that's basically the whole context of this testimony, is that there is a difference between, for instance, somebody being angry and somebody having a pattern that's destructive. There's a difference between somebody feeling jealous, which human beings feel, and them acting out in a jealous way and having a pattern of jealous behavior.
Let's assume a pattern of jealous behavior. That's what we're talking about. Can we assume that for purposes of this discussion?
So you're assuming...
No, I'm asking you to just think about this in terms of a pattern of jealous behavior. Can you do that?
You're asking me to hypothetical?
Yes, of course.
And a hypothetical that I have no evidence of.
It's a hypothetical, ma'am. Can you do that?
I can sure
Let's
try.
assume that the defendant has a pattern, a hypothetical pattern of jealousy. You don't see a pattern of jealousy in the journals, do you?
No, I don't.
But that lack of pattern in these journals could be because of the law of attraction, because that's a negative energy kind of emotion or pattern, right?
Objection speculation.
Well, this law of attraction, this energy that you've talked about, you're saying that a pattern of jealousy is a positive thing under the law of attraction?
I never said that.
It's a negative thing, isn't it?
A pattern of jealousy
Yes.
is a negative thing.
Right. And so that goes against the law of attraction, doesn't it? Where you put out positive vibes, right?
Yes.
And so if the defendant exhibited a pattern of jealousy throughout her life and didn't write about it in those journals, the reason could be because of the law of attraction that you've talked to us about,
Objection
right?
speculation.
Right?
Nobody has indicated she has a pattern of jealousy.
I just indicated it to you.
You've indicated it in
Objection.
a hypothetical. Overruled.
I indicated it to you, and you're saying that even if it's, my point is this pattern of jealousy, if there is one, would not show up in those journals because she wouldn't write about it, right?
Probably not.
And, ma'am, with regard to this pattern of jealousy, one of the things that we can look at for the pattern of jealousy is what an individual has done, in this case, the defendant, in her other relationships, right? That's something to look at, right?
Correct.
Not only is it what they do, but how they handle things, right?
Correct.
You're aware, for example, that the defendant dated somebody by the name of Robert or Bobby Juarez, right?
Correct.
And that when the defendant dated Robert or Bobby Juarez, they broke up at one point. You're familiar with that, right?
Correct.
One of the other things that the defendant testified to was that after they broke up, she got on the telephone and called Mr. Juarez.
Objection to state the entire point of that testimony.
Approach, please.
She and Mr. Juarez broke up. You knew that, right?
Correct.
After they broke up, the defendant was working at a restaurant. You're aware of that, right?
I don't remember.
If not, assume that that's what she testified to, okay?
Okay.
And she also testified that after the breakup, an older gentleman with a dog-eared Bible came into her restaurant. Assume that. Can you do that?
All right.
Do you know anything about it?
No, I don't.
And when this individual came in, the defendant testified that this individual was prophesizing the end of the world. Do you know anything about that?
No.
Assume it then. And according to the defendant, because this individual came in talking about the end of the world, she decided to pick up the phone and call Bobby Juarez. Did you know anything about that?
No.
That's what she testified to. After she picked up the phone and called Mr. Juarez, she identified herself. Assume that that's what she testified to. Do you know anything about it?
No.
He hung up on her. Assume that. In your assessment as a domestic violence person who has this schooling, in and of itself, if that's the first event, that's really not something that's too much of concern, is it?
No, it isn't.
It's just an individual, as you previously indicated, not wanting to let go, correct?
Correct.
Sometimes when people break up, one person wants to let go and the other person usually doesn't, is the way it works out, right?
Right.
Let's assume that the defendant also testified that after Mr. Juarez hung up on her the first time, that she called him a second time. Now it's beginning to get a little bit dicier because she won't go away, right?
It's not atypical. It's not unusual.
It may not be atypical, but it's not the first telephone call, it's the second one. It's now becoming, if we're going to start using the word pattern, it's now starting to become a bit of a pattern, right? Because it hasn't happened once, it's happening again, right? It's the start of a pattern, right? It could be.
It's possible,
All right?
but it's also typical for people to make more than one
Whether it's
call.
typical or not, I'm asking whether or not it could be the start of a pattern. That's what I'm asking.
Could be.
And during this second telephone call, assume that the defendant testified that during this second telephone call, she again was able to get a hold of Mr. Juarez. And after Mr. Juarez knew who it was, he again hung up on her. Assume that. In that relationship, assume that they get together. And after they get together, they break up again. And after they break up, Mr. Juarez is staying at his place of residence. Assume that the defendant testified to that. Do you know anything about that?
No.
Assume that the defendant then said, that indicated that even though they were broken up, she was still attempting to contact Mr. Juarez. Assume that. She testified to that.
All right.
Objection, Judge, mischaracterized testimony.
Overruled. The jury is directed to recall the testimony previously provided in this trial. You may continue.
And she was doing things in this attempt to contact him. According to her, she was buying things like groceries and leaving them at his doorstep. Are you aware of anything like that?
No.
Assume that that's part of the facts in this case. You previously testified that people who are starting to have this pattern, that's one of the things that they do. They look for excuses to keep contact with the person that has left them, right?
Different situation at the end of a relationship. People oftentimes don't let go right away. But I'd want to see how far it went and
I'm
What?
telling
You're gonna
you
tell
how
me.
far it went. That's
All
what
right.
the defendant testified to.
all right,
That she left things like groceries at his doorstep
all right.
for whatever reason. So again, even though the relationship is over, that indicates that there's still, on the part of the defendant, some action to keep contact, doesn't it?
Yes,
And again, if we take into account the 2 calls that were involved and now this contact, it does seem that there's the beginning of a pattern where the defendant is doing something in a positive fashion to keep the relationship going when the other party is done, right?
Objection, foundation, and timeline as to over what time period this is actually occurring.
Sustained.
Let's say it happened within a year, all right? Will you assume that?
that there's a year
No,
of constant
let me do it this
contact.
way.
I'm
Assume
not
that
sure.
there's a breakup, there's the calls, they get back together, they break up again, and then there's this contact, leaving things at the door, and that all that happens, let's say, between 6 to 8 months apart, this whole thing. Assume that.
Okay,
And then assume that the defendant told us that they break up again, and that the individual, Bobby Juarez, moved to Medford. Do you know anything about that?
I don't know about Bobby Juarez. I don't know much about Bobby Juarez.
Well, assume that he moved to a place called Medford, Oregon. That
Okay.
was the testimony, correct? And he started to live with an individual by the name of Matthew McCartney. Do you know anything about that?
I do know about that.
Assume that after Mr. Juarez moved to Medford, Oregon, that the defendant, even though they'd broken up and she's living somewhere else, she began.
Characterizes her testimony with regard to the breakup at that point.
Overruled again, the jury is directed to recall the testimony. You may continue.
After the breakup, and Mr. Juarez is in Medford, Oregon, living with Matthew McCartney, she testified that she then started going there on weekends. Assume that. Doesn't that begin to show a pattern of, number one, telephone calls, then contact at the door, and then after the individual, and they're broken up, moves away, she's still trying to keep contact. Doesn't that, and this is over a period of many months, isn't that the beginnings of a pattern?
Objection, Judge. Mischaracterizing Ms. Arias' testimony as to when the breakup occurred. They were not broken up at that point when she was traveling. So the hypothetical is not true.
Approach, please. Sustained. You may
And
continue.
assume that they were broken up when Mr. Juarez moved to Medford. Assume that, okay? Will you do that as part of the hypothetical? Isn't that a pattern developing here on the part of the defendant? A jealous sort of pattern where Mr. Juarez and her are broken up. She's making telephone calls. And after making telephone calls, she then starts bringing him stuff over to his house. And then after he moves away, she goes to the area where he has moved to. Assume that. Wouldn't that be the beginning of a pattern?
But they're not broken up.
No, I just said they were.
But that's the hypothetical.
Yes.
The hypothetical, because in reality, they're not.
You
correct?
believe that they're not, but let's assume hypothetically speaking, they are broken up.
Would that be the beginning of a pattern?
Yes.
It could be the beginning of a pattern.
Let's talk about Matthew McCartney. You're familiar with the relationship involving the defendant and Mr. McCartney, correct?
Correct.
And in fact, the defendant sort of went from Mr. Juarez and started dating Mr. McCartney, right?
Correct.
And there came a point when they started dating that, for whatever reason, there was going to be a breakup, right?
Correct.
And it was the defendant who refused to accept the breakup, correct?
She had a hard time with the breakup.
In other words, he wanted to break up and she did not, right?
Correct.
And when they were going through this process, he believed that they were already broken up, right?
When,
Objection made.
He, at some
Mistake.
point, they broke up at some point, didn't they?
yes.
And after they broke up, the defendant then confronted somebody by the name of Bianca, correct?
Correct.
Objection is stating the testimony after the breakup.
Overruled. And I don't think it was a confrontation.
I didn't say the confrontation, but it's after the breakup that Ms. Arias, according to you, goes and talks to Bianca, right?
Objection is characterizing the testimony.
I'm not talking about testimony, I'm talking about her understanding things,
Overruled.
right?
I'm not sure if they were broken up or not. I only know that she went and talked to Bianca. She talked to Bianca about the breakup. Yeah, I guess it was a breakup. She went to talk about, she said it was cheating. And she went to talk to Bianca about the cheating.
Do you remember writing about this in your notes?
I'm sure that I did.
And isn't it true that your notes indicate that,
Objection reading something that's not marked.
Overruled.
isn't it true that your notes indicate that they had already broken up when this talk between the defendant and Bianca took place?
I'd need to see my notes.
Okay? Take a look at Exhibit 613.
Are you asking me to just look at the highlighted section, or do you want me to read the entire thing?
What's that?
Do you want me to just read the highlighted section or the entire thing?
I want you to focus on the highlighted section, and then if you want, read the whole thing.
All right.
And isn't it true that there was this breakup, correct, between her and Mr. McCartney, correct? Yes or
Yes.
no? And isn't it true that it was after this breakup that there was this conversation between the defendant and Bianca, correct?
Correct.
Isn't that part of a pattern of jealous behavior in confronting somebody?
It didn't sound like a confrontation either by Mr. McCartney or Miss Arias. It sounded like she went and had a talk with her, maybe clarified, I don't know. But I didn't get the jealous behavior. I got the going to talk to someone. It wasn't, if it was real jealous, it seems like it would have been more confrontational.
So,
It's not described that way.
Mr. McCartney wasn't present for that one, was he?
No, but he said it wasn't.
And it was based on what the defendant told him, right?
I would suspect he talked to Bianca as well.
Pardon?
I would suspect he talked to his own girlfriend about it.
Again, now you're assuming, because it's to the benefit of the defendant, that Mr. McCartney spoke to Bianca. You don't know that, do you?
I know that Mr. McCartney said that it wasn't an adversarial situation.
Right. And the issue with that is he wasn't present, correct?
No, he wasn't.
Any information he would have received would have come either from the defendant or perhaps from Bianca, if he spoke with Bianca, correct?
Correct.
So anything that he knows secondhand, correct?
Correct.
And after this confrontation, isn't it true that the defendant went at some point, shortly after that, and slept in Mr. McCartney's bed without his permission?
Yes.
Again, isn't that, given in light of what happened with Mr. Juarez, and in light of what's happening here with Mr. McCartney, doesn't that suggest to you a pattern of jealousy?
It suggests a pattern of having a very difficult time letting go. But she's not controlling anyone with her jealousy. She's not controlling them.
Let me talk about another example. Take a look at this exhibit, 614. Recognize it?
Yes, the continuum.
And it's the same one that we talked about before, right?
Yes.
The only difference is that this one is clearer, correct?
Clearer?
In other words, the letters are clearer.
There aren't any exacerbating factors on it.
There's no what?
There's no exacerbating factors on
Right.
it.
Other than that, and that's the other change, but other than that, it's just a clear presentation of the items in the up and down fashion, right?
Judge May, she had the original ones to compare. Yes.
Judge, I don't want her to compare to the original. I'm just saying, isn't this something that that she's familiar with?
All right, overruled.
This is something you're familiar with and you put together, correct?
Yes, it's incomplete.
And that's fine, it's incomplete, but this is something you put together, correct?
Yes.
All right. I move for the admission of Exhibit 614.
Judge, may we approach?
614 is admitted.
Now, you indicated that that was, with regard to what we've been talking about, the defendant, that was not necessarily a pattern of jealousy, correct?
Right.
Actually, what we're really talking about is that's a pattern of stalking, isn't it?
No, it isn't.
Well, she's gone and contacted Bobby Juarez on the telephone 2 times after the breakup, right?
She has.
And she's left things at his door after they've broken up, correct?
Stalking implies fear.
Yes or no?
Stalking implies
Yes
fear.
or no?
Incorrect. Stalking is about fear.
Yes, what's the objection?
The objection is she clearly cannot answer the question with a yes or no answer.
All right. Overruled. Restate your question.
Isn't it true that she, with regard to Mr. Juarez, she left things at his doorstep, correct?
Yes.
And isn't it true that with regard to Mr. McCartney, one of the things that she did is that she went and spoke to the person that she believed that he was seeing, correct?
Correct.
And then she slept in his bed, right?
She did.
And with regard to Mr. Alexander, isn't it true that one of the things that you know with regard to the Reagan Housling instant messaging was that Mr. Alexander was exceedingly afraid because of the defendant's stalking behavior?
Overruled. You may.
I don't know that he's exceedingly afraid. I don't get.
Judge, may I then ask her I think we'll need to approach him.
Yes, all right. Ladies and gentlemen, we're going to take the evening recess. During the break, did you have an opportunity to look at your schedules for the dates I indicated earlier? Let's start with this Friday, April 12th, from 9:30 to 12:30. Is there anyone who could not be here from 9:30 to 12:30 this Friday? All right, thank you. Please plan to be here. For April 26th, from 9 to 4, is there anyone who could not be here? Thank you. Please plan to be here. Now, May 3rd, it appears we may not need that date, but is there anyone who has a problem with that date? Excuse me. All right, please keep that on your calendar as well. All right, please remember the admonition. Have a nice evening tomorrow morning, 9:30. Have a nice evening.